Welcome to Difficult Research. Welcome to Cresha's channel, Difficult Research. Cresha K. Easton is a member of the Woodcock family, a niece of Charles Vallow, an aunt of J.J. Vallow, a cousin of Tylee Ryan. She has been on a mission to seek justice by uncovering the troubling beliefs of Cresha's former aunt, Lori Vallow, and her husband, Chad Daybell. Throughout this journey, she has encountered powerful individuals within the mainstream system, revealing the truths we've been misled about. You can help amplify the voices of Tylee, JJ, Tammy, Charles, and Joe by joining Cresha here and joining us in getting justice for Charles Vallow. Morning, y'all. I don't know whether I'm on here or not. Morning, y'all. Okay. As usual, I don't have control of all the tools. Well, oh my gosh, y'all. Here we are, the day of final remarks, final statements. And we've been doing little chats back and forth this morning. Let's see. I'm going to read some comments and see, because they must be getting ready to start by now. Oh, I want to show y'all the front of the courthouse. That's what I'll do. I'll do that while something besides my big old face to look at. How about, let me invite, share screen. Yeah, this is the front of the courthouse this morning. So I'll have that be in the background. And I'm thinking that this must be, right in here must be where Tracy is, because Tracy said she was fourth in line. So we're so excited to have Trace be there representing for us. And also, we appreciate Joe Smo's support, and we want to support him also. I've put the link. I think that I pinned a link if anybody wants to help Trace with her lunch and expenses. She's been going down here for weeks, and we appreciate it so much because she has enabled us to ask questions and know things that we would have no other way of knowing because we know Trace and we can ask her. And also, I said I was going to read the comments, so let me get over here and read them. Okay. Hey, Fancy Nancy, Beach Bum, X-Files. Buddy, come on in. We're going to get ready to get some justice. 5 is much better. Okay. Oh, yeah. It was like, so, KJ, I'm glad you're here. Oh, boy, yeah, we're getting some. I've never seen other people do that. It's so fun seeing the celebrations and the hearts and everything. Did I? KJ's here. Janelle's here. Thank you, Janelle. Oh, my Janelle. We're going to have to interview some more because I got some more questions. And dang, I wish I had some of them funeral potatoes you made. Okay. Lamisi says, hello to all my favorite people. Fancy Nancy says, Janelle, she misses you too. She was excited about, oh, I know it. You were like a dose of medicine for Tracy, and we're so grateful for it. I wish we could get a dose of Janelle to all of us. She is a healing lady. X-Files says, I feel like the New Year's countdown for the ball that's going to fall on Lori. That's exactly, yeah, I like that. No, I don't know. Let's see. The X-Files, oh my goodness, I know, right? I was thinking that I messed up and that she might just empower her to be more in the spotlight. She may do it. It's no telling. It's no telling. She may comment, do everything. Karen Lee Holland, hey Karen Lee, and Halo Brands, Dora Opinion, Jet Set J. She says, hey Krisha K, God, Jet Set J says, God, please hear our prayers for a guilty verdict. Yes. Little Brand says, interaction with the video helps Krisha be seen by the algorithm. That's right. So everybody, please hit that. There's 75 people in here. Let's see how many. We only got 45 likes, so let's get those likes coming, y'all, because that'll put it in the algorithm and that'll help Krisha, and in turn help the kids and have justice for them. Let's see what this says here. Okay. Well, man, here we go. Sheila M says, hi, everybody, justice for Charles. Karen Leah Holland says, it really looks like Joe was murdered with the evidence from these trials. Is Annie is there due to, yes, that's right. Exactly. Karen, that's right. I really believe that she killed him too. I really do. And I hope that that someday that there will be justice for Joe Ryan instead. I think that everybody agrees on that. Thank you for allowing us to participate for the information. Thank you, Liza Joe. Of course, you're invited over here for information and encouragement, hugs, whatever we can give you, Liza Joe. Whatever hugs and stuff you give us, we're all about it. Desert Rain says, I can't use emojis. Something is wrong with my YouTube and computer, and all my emojis come out as camels. So weird. That is weird. Beach Run says, we appreciate you staying up and supporting Charles and the family. Little Brand says, thanks all for being here. Justice for Charles. Let's see if we got some down here. Hey y'all, I bet the hussy, Heather Feather says, I bet the hussy is terrified just to stay out of her cage longer. Donna Coggins says, y'all, Pussycat says hi. Pussycat, you, I don't recognize you here, but welcome. We're here for justice for Charles. Exactly. You may have been here all along. I see you're familiar with our subject matter, the hussy. Heather Feather says, I bet she changes her mind today as device. I kind of wouldn't put it past her, Heather Feather, because she wants to type as much time as she can while yapping about she wants a timely adjudication. Janelle Murphy says, can you imagine the Easter weekend Lori must have had? Oh my God. Her and her, she's Jesus' favorite. Pussycat said yes. Divergence says, good morning, all. Justice for Charles. Fancy Nancy says, Janelle, I've thought about that. Patron says, hey. Karen Lee Holland, Helen, the Scottish Llama, Lorraine, Alavino, Little Brands. She's saying hey to everybody. The pot stirs. I bet CSI crowdsource elimination says, I bet she tries to testify in her closing exactly because she thinks somebody can ask her a question there. Donna Coggins says, I just got a notice that I got a certified letter from Mary. Oh, dang, Donna Coggins, you may be getting, uh, what do you call it? Oh, my ears itching all of a sudden. These things, mm. Do you think maybe you're going to have a summons to go to jury? I watched Nate Eaton earlier, and he said someone here in Arizona bought Lori's clothes for the court. I heard that too, Desert Rain. Somebody bought her some clothes and sent them to her. If we had known that was a possibility, we could have sent her some stuff. We could have sent her a burlap bikini to wear. Lori says there's no way she will testify. Just a coward murdered. Probably because she don't want no questions. Beach Bum says, Donna Coggins, wow. A snap, wow. Janelle Murphy says, I think she may testify because Lori cannot help herself. She wants the last and final word. That's what I keep thinking too. She's a coward, but I mean, she says all kind of crap like nothing, like we don't know anything. Pussycat says, buy her a burlap bag. Heather Feather says she is so narcissistic that she might think she can convince the jury she is innocent. Patricia Burns says if she doesn't the trial and the media spot if she doesn't get the media spotlight will be over and flash. I don't see her waiting on that. Being a narcissist. A Vistex a burlap bikini, yeah, with a shock belt. Yeah, Fancy Nancy. She could have wore a burlap bikini with a shock belt. That would have been just so Lori. Christina Jays, I think she will. I think she will. Okay. Put a 1 in the chat if you think that Lori will testify. Put a 2 if you think she will not. 1 if she will testify. I don't know. 1 if she will testify. 2 if she will not. Okay. KJ says that it don't matter what she wants to do because those jury instructions have been approved on both sides. She won't testify on stand, but will try to testify and close the statements. Yes, okay. All right. She's such a she tries to cause trouble. Okay. Most of the people were thinking that too, I'm seeing. Y'all, please hit the like button. If we hit the like button and interact, a lot, it will put it in the algorithms. More people will see it, and they'll jump on. Let me see if any of these folks in the courtroom are saying anything. I'm gonna look at my phone. For just a second. Okay, okay. So let's see what if Justin Lum is already. I should have had that pulled up. Because it should be time for it, huh? Hang on, folks. Yeah, I act like this is my first rodeo, don't I? Well, so they're doing that, and hang on just a minute. Y'all talk amongst yourselves. Can y'all talk amongst yourselves for a minute? Let's see. Well, I can't do that because I forgot I took the mouse in my mom's room for that computer, so I can't mouse on it. So I can't do what I was going to do. So I'll do it here. Y'all hang on. Pretend I'm not looking funny like I'm hunting for something. Let's see. Okay, so now I'm going to see if Nate is posting anything from the internet. I mean, excuse me, from the courtroom. I know they're sitting in there because Tracy said that they're in the courtroom. Well, Justin has not posted anything else. Let's see if Nate has posted anything else. Okay, Nate is posting. He said, well, probably we don't. Nate said that he stayed in the hotel next to the Maricopa County Courthouse last night. And I guess I could show this, share this instead. And he's showing his view. He from his from his room, he could see the people lining up to go to court. Pretty cool. I guess that's what we can do. We can watch Trace for a few minutes. That's what we'll do. Okay, so let's stop it there. So this morning, Trace got there early, getting in line. And so when Nate got there, Nate went around interviewing people like he's been known to do in the mornings. And so this is the little interview that he had with our very own Trace on the case. So here, well, fiddle.
You know, I think they both said they would take less than an hour, and it seems like the case will go to the jury. So I think it'll just depend on how many questions they have, whether they can agree on a verdict, and I guess time will tell. But I would say it's very likely we could see one later today.
Okay, thank you, Erica, putting her on the spot there.
No worries.
For a good interview. Yeah, she has been here every day, like sitting on the floor. These TV reporters have so much to do, all these reports to file. So you all media, were you first?
Annie was first.
Oh, Annie Cushing.
Uh-huh.
Okay. Well, were you second? Can I interview you? Okay.
Yes.
So why did you come out so early?
Because I expected this.
Yes. You've been here every day.
I've been here every day.
And what's been your biggest takeaway?
As in, give me some.
Just the trial. What stood out to you? Like
I
what
think
witnesses?
you know what really shocks me is that these people majority are not from Arizona. If you go down and talk to them, there's so many from out of state. You know what I mean?
But you're from here.
That? I am from here.
Yeah. And what got you interested in the case?
I am a mod for Kresha for her YouTube channel.
So you've been following it from the beginning.
From the beginning.
Yeah.
Yeah.
You think we'll have a verdict today?
I don't know. Do you?
I think it's possible, but maybe the jury will want to sleep on it tonight.
They might, or the judge might be like, go home on it. I don't know.
Yeah.
He's kind of, sometimes he just closes things down at 3 and,
Right.
so.
Thanks for letting me interview you. So, as she said, we could have a verdict today. I'm going to put my mic back on. Or we might not. Here's how today's going to work. Let me get this microphone back on. There we go. Okay, so the court will begin at 10:30. The jury will report at 11. And they will be given jury instructions, which should take about an hour. And after the jury instructions, we'll break for lunch, and that'll be about an hour. And then at 1 o'clock, the closing arguments will happen. And that Lori says that she will take less than an hour. The state says they're planning on about an hour. So really, the jury could have the case by 2:30ish. So I do want to get your thoughts on, do you think there'll be a verdict today? And what time? Arizona time. Give me your time in Arizona time. What you think will happen here in Arizona. So let me go down to the line here, introduce you to a few more people. There can be a rebuttal today. You're saying no. Someone's saying no, there won't be a verdict today. And that'll be interesting if there's not, because it could continue into tomorrow.
So we're back at the courthouse. We didn't want to share all of Nate's content. So let's go. Let me go back up here and read some of these comments. Janelle, you watching yet? Janelle's here and she's watching. How far did I? Okay. I saw Nate's stream earlier. Yes, a lot of people do. Many Mimi Jojo says, I was wondering if the prosecution will bring up Lori's many claims that the evidence would, but never showed. One particular is the saying that someone from high school saying he batted right-handed. I wouldn't think that she could bring in a dang witness in her closing statement that said he batted right-handed, or any kind of handed for that matter. But I don't know. So I know that Trace cannot come up, but if KJ or if anybody for that wants to come up and do some commentary with me until they start, it'll be fine. I feel like that it will be it'll be a while before we actually see court, but they should be actually already doing some stuff down there. Let's see. I don't know if he's okay. So I'm going to share this for a minute. Nate says he just saw Brandon Boudreaux walk into the private room near the courtroom. Madison County Sheriff Ron Ball is also here from Rexburg, waiting to get into the courtroom. So I'm gonna put that in the chat. So let's go back over here and see if Justin Lum has any comments. Justin Lum doesn't have any comments yet. I guess I should be sharing Justin's face, but I'm not, so. I guess it does change, don't it? Wow, so Brandon's there and Ron Ball is there. Just looking over her. Yes, Trace is still on a 30-minute delay. Is Trace in the, have we seen a comment from Trace in the, let's see. Trace is not in here right now. So Janelle says, Fancy Nancy, they blocked from being online because they told me they had too much public records in it. I don't get that. They published my book and offer a physical copy, but no. Oh, I don't know. I'm probably reading something, part of something else. Thank you, my friend. Yes, and I really, let's see. I thought Nate mentioned a 5-minute delay. It's a 5-minute delay on the juror. Let me read that again, I think. I put that in the court. Let's see, maybe I'll hold on. Hold on, y'all. I think that earlier today. Oh, it was Justin Lum. Let's see. Mama is cooking something. I have my olfactories are. Here's the schedule for today. The video will be a 30-minute delay except for the verdict. Judge Justin Berensky is permitting a 5-minute delay on the verdict. So the jury instructions, well, how can they do that? That seems backwards to me because I talked to my mother about this morning and I kept saying jury instruction and then closing arguments, but that seems, are the jury instructions to the jury? They're going to have jury instructions before the closing argument. Is that right? Am I understanding that right? Because that seems backwards to me. It seems like to me, who's in the KJ? Are you in the chat to answer that question for me? I'm trying to get down here to the bottom. Okay, here's the question. According to the schedule, let me get the schedule because y'all can't see it, what I'm asking you. See, here's the schedule according to Justin, according to Nate. But we, of course, these are all Arizona times. And so, like, for instance, we live in Central Time. And so it says court begins at 10:30. So that's 12:30 our time with a 30-minute delay would be 1 p.m. would be when we would see that. And then at 1:30, if it's there would be jury instructions. It just seems like to me that it would confuse or does the jury getting the instructions? I guess they are. So the jury gets the instructions before closing arguments. Did we do it that way before? Is it always that way? I guess that's my question. It seems like that's out of order for how I things in my brain think they should go. But the closing arguments will be, I see the schedule, but I'm just saying, is that always the way it is? Closing arguments, then the jury deliberates. I guess you want them to have that fresh on their mind, the closing argument, and not a bunch of uh, if or and what rules. Clisset, did I see Nate interview Trace on the case live this one? Yes, you did. We're very excited. I've doxed her face out. Now y'all know our sweet Trace face and voice. Fancy Nancy says, I thought that instructions, me too, but I guess we did. I mean, yeah. Janelle Murphy says, I hope that link works to find my book. I can put Janelle's link to get her book. Let's see. Because they don't normally work if you don't have a wrench. I'm getting to it, y'all. Okay, this is a link to Walking Through the Doomsday Darkness. This is a link to um Janelle Murphy's book. I'm gonna put Janelle's book. Well, that ain't right. So, hold on, hang on, y'all. Hang on, y'all. Good grief. You think I forgot how to dang copy and paste. I put Janelle book instead of Janelle's book. But y'all get it. I'll try to do it better in a little bit. So they'll have lunch at noon, which will be 2 o'clock our time. Closing arguments will be at 1, 3 o'clock our time. If that takes a couple of hours, probably. Calista says maybe the jury instructions, judge will remind them the closing arguments aren't evidence. I hope so, knowing what Lori is about to try. Yes, Mel Max says, hi everyone. Natalie Huber says, y'all, I have a crazy question. During Nate's live this morning, I saw people with shorts on. The courthouse allows that? Doesn't over here. I was wondering the same thing. But you know what? They may have a skirt or something. I don't know. I'm just making this up. But a lot of the people in the line have support people and that aren't going in, that bring them a chair and some water and some lunch and things like that. And it may be they had a skirt to put on over their shorts before they go in. I don't know that. That can be one of the questions. Hey, who asked that question? Natalie Huber. We're going to ask that question to Trace when she comes back in, if those people wore shorts in there or if they changed their clothes. So this is going to be kind of a weird day today about how they do it. So let's go back over here and see if Justin Lum has said anything else. Okay, so Justin says closing arguments are set for this afternoon, and we will see what Lori Vallow Daybell has to say to the jury before they begin deliberations. Let's see what Nate says. The video from today. Oh, that's where it's concerned. Okay. We already did that. Okay. All right, let me go back and see our chat. I know, Shelby. It's like surely they won't. I mean, this is what I would think. I would think that they would do closing arguments, and those people will go home and get a good night's sleep, come back tomorrow, and convict her butt. But I don't know. Let's see. Let me see what I need to take that off. Okay, let's see. All right. Well, that's lovely. Okay, so let's see what Nate has. Justin might have said anything else. Nope. Oh, well, I thought Megan was one of mine. I guess not. I'm just learning this. I don't normally even use Twitter. So let me go see. All right, I'm just making sure that I'm not missing something that I'm supposed to be doing. Okay, let's see here. I tell you what, I think what we should do while we're waiting for a few minutes is maybe watch a video that Kresha put up yesterday or last night on difficult research that I know we've seen before, but it's important that we first we're going to look at this one.
Quote, taken on January 30th, 2019 at 16:33 hours. Location was 2267 East Tomahawk Drive, Gilbert, Arizona. Shared residence for Lori and Charles. The involved parties were Charles Vallow and Lori Vallow. Synopsis. Telephonic report. So this is a phone report. Charles called GPD to make a report of Lori acting strange and making threats. Some of the strange behavior noted by Charles to GPD was that Lori felt she was living her sixth life. She was previously married to Captain Moroni, an LDS church figure, in a previous life. Lori felt the second coming of Jesus Christ was to be in 2019, and preparations needed to be made. Charles related that Lori felt Charles was now someone else by the name of Ed Schneider. That's in quotes. It was not known to Charles why she believed this. Lori had made statements about murdering Ed Schneider, and how she was going to destroy Charles. Charles further reported Lori felt she was a god. Charles was in Texas when making this report. He was advised of options that included a psychiatric evaluation, community bridges, and a petition to get a mandatory evaluation for Lori. Charles reported he was returning later that day and would go seek the order when he arrived. Charles did not want GPD to make contact with Lori as he felt it would only aggravate the situation. Number 2, GPD report 19-00001819, quote, special incident, unquote, taken on January 31st, 2019 at 00112 hours. Location was redacted. Drive, Gilbert, Arizona. Shared residence for Lori and Charles. Involved parties, Charles Vallow and Lori Vallow. Synopsis. Body-worn camera utilized. GPD received emergency mental health petition at 2338 on January 30th, 2019 for Lori Vallow that was completed by Charles Vallow. Charles reported the inability to contact his children and was waiting outside for GPD to respond. Report indicated Charles reported to GPD that Lori's behavior has changed over the last 4 years and recently became worse.
I went to the CSI file report, which is the community bridges or something, file report.
So you did the petition?
Yeah, they ordered pickup.
Okay. What time did you do that?
Hour and a half ago.
Okay.
This report indicated that Charles stated Lori referred to him as quote unquote Mick Snyder with an M. He also related that Lori would or could destroy him.
So what makes her a danger to herself and to others?
She threatened me, murder me, kill me.
She threatened to murder you?
Yes. And she said,
how did she do that?
My bishop right there is in the car. He was on the phone with me today when she said, I will have you destroyed, is what she said there.
Okay, that's not a threat to kill you.
Yesterday was a threat to kill me.
Okay. What did she say yesterday?
She said, you're not Charles. I don't know who you are, what you did with Charles, but I can murder you now with my powers.
Okay.
Okay?
All right.
I said, I'm gonna kill you too. Yesterday was I'm
So
gonna
she's speaking as a spiritual being.
She's not here. She's lost her reality.
Is this just all recent, or has it been going on?
It's been going on for about 4 or 5 years. It's gotten really, really bad lately. She goes to the temple every day and speaks with Moroni and Jesus Christ. And they tell her what to do. And now she came to her today, and last couple of days she says, I'm not Charles. You're not Charles. You're Mick Schneider. I don't know where she gets this name from. She got all this stuff from these people in Utah who tell her how many past lives she's had and probation she's had. And she's was married to Moroni way back when, and she was also married to James the Just. And
okay, this is all foreign to me. So
it's foreign to me.
Well, I'm not LDS.
It's crazy stuff.
I know you're using LDS terms here.
But it's just she's nonsensical.
No mention had been made by Lori to want to hurt any of the children. Charles was unable to have any contact with any of the children for the last 2 days. Moving on to page 389. Charles went to Texas on January 29, 2019, and upon his return to Phoenix, he found his truck that had been at the airport was missing. He suspected Lori taking the truck without communicating it to him.
Okay. And I haven't seen my.
Is he the older one or the younger one?
He's 6.5 years old.
Okay.
Okay. I want to do this now. You've got a pickup order. Am I correct?
We do.
Okay. If she doesn't answer, what do we do?
If she doesn't answer, we can't enforce the order.
Can I break into my house?
Do you live here?
Yes, I do.
Okay.
My lease. I pay the lease.
Do you guys have any orders of protections against you?
No, we do not.
No police reports?
No, nothing.
Okay. So how does she pose a threat to your children?
I don't know what she's going to do with them. I don't know if she's going to flee with them. She's going to hurt them.
You don't even know if she's here, right?
Today on the phone.
Tonight, a nationwide search for 2 missing children has come to a gruesome end. Family members confirm that the remains found on Chad Daybell's rural property in Idaho are the bodies of his stepchildren.
I can't. All the cars are the garage is closed. I don't know. She locked the garage door.
I know.
Been up there yet.
I know. But what I'm hold on.
Sorry.
What I'm saying is, do you normally park two vehicles in the garage, inside the garage?
Correct.
Okay. So it's a possibility that her car and your truck are inside there?
I don't think she could fit my truck in her car at the same time. She may put them somewhere else. She said to me, all your stuff, Charles' stuff is gone. You're not Charles, your stuff is gone. I don't know what that means.
And how long have you been trying to get in touch with the kids?
Since yesterday.
Since yesterday? Like last night or yesterday morning? Or?
About landed in Houston Tuesday about 10.
Okay. Why did you leave?
Business trip in Houston.
Okay. And when did you leave?
Tuesday morning about 5 a.m.
Okay. Tuesday. All right. Wow. It's
Wednesday night.
So you left yesterday?
Yeah.
You left yesterday morning.
Mm-hmm.
Flew to Houston. Mm-hmm. Flew back today.
Mm-hmm.
Tonight.
She canceled my flight. She came to the airport, took my truck.
Did she tell you that?
No. She knows the code. She knows where it's parked. She went.
Did she go with you to the airport?
No, but she's been. I go to the airport. I fly 45 round trips a year. She knows where I park. I've got handicap plates because JJ's handicapped.
Uh-huh.
So,
did you file a stolen vehicle report with
I
Phoenix?
know she took it.
How do you know? You suspect?
I suspect.
Okay.
I suspect.
All right.
I know your term. So.
Okay.
Yeah, but
without concrete evidence, we can't say for sure.
Okay. And she has the keys, the code. It's a Ford. The code, door code.
Door code.
And I just want to see my boys okay. And she's got a pickup order. I need to go. She needs to go, and I'm gonna take my son.
So you normally live here?
Yeah, oh yeah, I live here. Okay. Yeah, all my stuff's in my house.
Okay.
We got a service dog in there, beautiful dog. My daughter's in the front window right there.
So let me ask you this: when you came back, why didn't you just go to the home?
Because she told me not to come near it. All my stuff is gone. Okay. I'm not stupid. She could have done anything.
Okay.
I thought this would be the best way to do it. With what she's gone through and what Gabe witnessed with me on the phone today, I thought it was best to have her. She's psychologically, she's gone. Something's happened to her.
How old is she?
30, 45.
45.
Beautiful
So,
woman,
if we talk to her, is she going to be able to have a rational conversation with us?
Oh, she will. I'm sure she will.
Okay.
Yeah, she's just.
She'll probably tell me I'm crazy, huh? Is that what you suspect?
Probably.
Okay.
You're a dark spirit. That's what she's going to tell you.
Okay.
I'm a dark spirit. Gabe's going to be. He's our bishop. He's going to be a dark spirit. Whatever that means. You're evil.
And you said this has been going on for like 4 years?
Well, it's to an extent, but it's gotten really bad the last several months. And I've been trying to ignore it because hoping it'll get better.
Is she on any medications?
No. She won't do medications.
Has she been to a doctor?
She won't go to the doctor because she's a translated being, and they would find out she's translated. She cannot be killed. She cannot die.
And that's what she thinks?
Yes.
Okay. And she's been telling you that?
Yes, and Gabe too.
Okay.
He heard this, not just me. This isn't coming. I love her to death. This is killing me, officer.
Oh, I can understand.
Our 13th anniversary is next month. We've been at a great marriage. All of a sudden, the last month it just blew up.
Mm-hmm.
She just lost connection.
Okay. So has she made any statements about wanting to hurt the children or anything?
Today she said with Gabe on the phone, come take the kids. I don't care what happens to them. Come take them.
Okay, but she didn't make a direct threat towards the kids.
No, not a direct threat.
Okay. And then she said that she would murder you through a spiritual.
No, she said, I can murder you.
I can murder you.
And
she's talking in a spirit.
I will kill you.
Spiritual.
No, she's talking physically. I will kill you because you're not Charles, and nobody will care.
Okay. So she at this point doesn't think you are her husband?
She thinks I'm Nick Schneider.
Who's Mick Schneider?
I have no idea.
Okay.
It's the name she used. I don't know where it came from.
Okay.
I'm just like, I'm as bewildered as you are. This is so foreign to me. Normal people, as far as I'm concerned, that, this happens, it just drives me, I don't know what to do. I need help, and she needs help. She needs help. And go to bed. I got a lot of stuff to do tomorrow. I got to take my son to
And
school.
you just didn't want to go inside because of the statements that she made?
She took my car and I suspect she took my car and my keys. I had no keys to get in.
Oh, okay.
No garage door opener.
He further stated Lori had taken the funds from the bank accounts.
Okay.
She knows what she's doing. She took $35,000 out of our bank account today. I can't make payroll Friday for my company. It's just, she changed our bank account numbers. I had to change it myself to get back in, and I saw all the money's gone. I've got $7 in my name.
So, what's your first name again?
Charles.
Charles. Charles lives here with his wife and 2 children. Charles was away on
There's a
business.
third nephew upstairs. His name is Zach. He's 19. He's our nephew. He can stay with us.
Have you tried to call him?
Yeah, he won't call me back either.
Why won't he call you
I
back?
don't know.
Okay.
That's what I'm worried about. I hope they're okay, but I don't know.
I'm Kresha Kay, a dedicated advocate seeking justice for my 3 family members who were tragically lost to the heinous crimes of Lori Vallow Daybell and Chad Daybell. Through my YouTube channel, Difficult Research, I share updates, commentary, and personal reflections on this complex case. I am committed to honoring the memory of my loved ones and raising awareness about the devastating impact of violent crime. Thanks for being here. Don't forget to like, share, subscribe, and all that good stuff. Love always wins. Justice for Tylee, Charles, Tammy, JJ, and Joe.
They were brought in for. So there are probably 12 major points, I'm guessing, in the case, the different points that connect her to the conspiracy. There is zero sympathy, I think, for her and the hypocrisy of some of her testimony, some of her cross-examination, the gal that had gone out with Charles the night before, her trying to ridicule her when she is having an affair with Chad Daybell. There are so many factors in this case which I think has to have a powerful impact on this jury. And that's why I believe it's going to be a quick verdict.
Mel, for those that are unaware, from a judge's perspective, what will Boreski do? Will he get an indication from the foreman to find out where the jury is and whether or not he wants to keep them, say, past 4:30 or 5 on Monday? If there's any indication that they might be close, how does that work?
Typically, what happens is they operate on a work day. When I was a Superior Court judge, we would generally go till 5. I would send the bailiff to the jury room. It's almost 5. Do you want to recess for the day? The jury then makes the decision, informs the bailiff. We want to continue to deliberate. Typically, the bailiff will let the jurors know if you do stay, we can have food brought in, or you can go home for the day and return tomorrow. Uh, Oftentimes, if they're close to a decision, they're going to want to stay and complete the verdict so they don't have to come back the next day. I would suspect that's what would happen. The closing arguments starting Monday morning. I see the prosecutor and Lori probably having their argument completed by 12:15 or 12:30. The state may have a short rebuttal in the afternoon. I don't know.
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing? Anything else? Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially
So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me, what's 286 is? Whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected.
All right.
State redacted out the beginning, the end discussions of highly. I would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors in all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out. But it's just more or less what was played in during testimony. Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the exact
My
testimony.
advisory council checked the FTR, and that's exactly what was said. That's exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes.
Okay.
The full interview, the defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right. We're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
Can y'all hear me? So I guess we're waiting on them to get the juror in the room and or something. I don't know what exactly. That was them. They surely didn't do all that they didn't do that in front of the jury. So now they're going to bring the jury in and talk about jury instructions. And I'm guessing this is about right. There'll be a little delay. Well, wow. That was quite a bit of, can you imagine? Okay. And the channel is Life Without Pro. I've seen that, Life Without Pro. Krisha and I were talking about that. I I have seen so much over the past few days. I forgot now, but I really enjoyed it. It was her. She usually talks by herself, but her sister was with her this time. A Life Without Pro, and she was at the courthouse too. I saw her. Okay, let's see if what say Justin or Nate. I guess they got to make copies. So Nate hadn't said nothing in a minute. Jury instructions are 11 a.m. Okay, that's so really that's another be 5 minutes before 1 here. I'm trying to think. So while we're waiting, Krisha had another video of Charles. Okay, so this is part 2.
Number 2, GPD report 19-00001819, quote, special incident, unquote, taken on January 31st, 2019 at 00112 hours. Location was redacted. Drive, Gilbert, Arizona. Shared residence for Lori and Charles. Involved parties, Charles Vallow and Lori Vallow. Synopsis. Body-worn camera utilized. GPD received emergency mental health petition at 2338 on January 30th, 2019 for Lori Vallow that was completed by Charles Vallow. Charles reported the inability to contact his children and was waiting outside for GPD to respond. Report indicated Charles reported to GPD that Lori's behavior has changed over the last 4 years and recently became worse.
I went to the CSI file report. Which is the community bridges or something. File report.
So you
And they
did
ordered-
you did the petition?
Yeah, they ordered pickup.
Okay. What time did you do that?
Hour and a half ago.
Okay.
This report indicated that Charles stated Lori referred to him as quote unquote Mick Snyder with an M. He also related that Lori would or could destroy him.
So what makes her a danger to herself and to
She
others?
threatened me, murder me, kill me.
She threatened to murder you?
Yes. And she said,
How did she do that?
my bishop right there is in the car. He was on the phone with me today when she said, I will have you destroyed. Is what she said there.
Okay, that's not a threat to kill you.
Yesterday was a threat to kill me. The day
Okay.
before
What
was a threat to
did
murder
she
me.
say yesterday?
She said, you're not Charles. I don't know who you are, what you did with Charles, but I can murder you now with my powers.
Okay.
Okay?
All right.
Says I'm gonna kill you too. Yesterday was I'm
So
gonna
she's
kill you.
speaking as a spiritual being.
She's not here. She's
Okay.
lost her reality.
Is this just all recent, or has it been going on?
It's been going on for about 4 or 5 years. It's gotten really, really bad lately. She goes to the temple every day and speaks with Moroni and Jesus Christ. And they tell her what to do. And now she came to her today, and last couple of days she says, I'm not Charles. You're not Charles. You're Mick Schneider. I don't know where she gets this names from. She got all this stuff from these people in Utah who tell her how many past lives she's had and probation she's had. And she's was married to Moroni way back when, and she was also married to James the Just. And
Okay, this is all foreign to me. So
it's foreign to me.
Well, I'm
too.
not
It's
LDS.
crazy, it's crazy stuff.
I know you're using
It's-
LDS terms here.
but it's just
Okay.
she's nonsensical.
No mention had been made by Lori to want to hurt any of the children. Charles was unable to have any contact with any of the children for the last 2 days. Moving on to page 389. Charles went to Texas.
So I think these videos were pretty similar, and poor Charles, he was so much asking for some help, and he just couldn't get it. He just couldn't get it. I mean, he even mentioned Bishop Bonilla in this conversation. Trace says she's missing her Janelle. She's not going to testify because she's already said she's going to close today. Rest. She's going to, as KJ says, she is going to testify, but it's going to be she's going to testify, but it's when she's not supposed to. Okay. We're hoping juror 15 behaves. I'm not sure what that means, but I hope they do too. The cops I encountered are not the brightest folks out there. Oh, well, we better not say that. Fancy Nancy says, Janelle, thanks. We'll reach out. When I get your book, I will mail it. I will mail it to you for an autograph. Oh, Trace, yes, no snafus for Juror 15. Detective's daughter wants to know what's up with Juror 15. 15 may not be picked. Oh. So let's see what's going on. I'm checking back and seeing what's going on at these different places. Oh, it looked like something was getting moved there. Okay. I think we're back in session. Let's see where am I at.
Needs to be brought up and hashed out. This is the time, confirmation on whether or not Lori Vallow Daybell intends to testify, present evidence. We know that this is like the third time she's been asked. She's been given some time to decide that, and looks like we're getting some audio here. Judge Boreski
All
on
right,
the
we're on the
bench.
record, State of Arizona versus Lori
We should
Daybell,
address the
CR
audio will be a little choppy to begin with, but it will
21-001-704.
improve within the first couple of minutes.
Why don't I have the state announce? And the defendant?
Lori Daybell.
All right, we met on Thursday. We put drafts on your desk this morning. Last week, let me just pull up that email. No email, please. Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do as well. Occurred since we met Thursday. I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. Any other record you want to make on mere presence?
Oh, yeah.
All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from Mexican.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have 2 issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing 2 numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected.
All right.
The state redacted out the beginning, the end discussions of highway. That would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors between all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out.
Yes.
But it's just more or less what was played in during testimony.
Correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That's exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They have access to that.
Whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Tylee said or did or didn't happen, the hearsay parts were the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened
So we have
there.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
Lori Vallow Daybell taking up a couple of issues with Judge Boreski, and mainly, first off, was talking about alternate jurors and how that's decided, and we talked about that. It's very simple and efficient. You just draw two names, or two numbers, I should say, and they'll have 12. But then now she's back on this exhibit 286, I believe, on the interview done with her, conducted by Cassandra Inclan. And there's a certain portion, number of minutes that have been admitted as evidence, but she's asking why the full 55 minutes weren't admitted and how it was said or confirmed by Inclan that this was the full interview. And the judge explains time and again that there are portions that are redacted because of hearsay regarding Tylee Ryan. Like, I don't know what she's reaching for, grasping for straws here. She had a chance to address this even Thursday, right?
She did, and the judge, was clear in that Lori wanted to make sure the jury understood this was just a portion of the interview that they saw and heard, but ultimately the judge was like, well, if the whole interview was to be included, then that should have been brought up during the trial. Whether it was 20 minutes, I think it was, that was shown of the almost hour-long interview. As we said, this is, again, some last-ditch stuff. I don't know that ultimately she would want the whole thing played. Maybe she does, but I think at the end of the day, this is another case where do you really want to open that box?
Yeah.
And in the event, again, the judge said, look, this could have been brought up in cross. You could have asked Detective Inclan about it. You could have made the jury aware that the video that they're seeing is only a snippet of what was done. But again, all of this could have been brought up earlier and it wasn't.
This shows she's not an attorney.
Right.
She's acting as her own attorney. It's very clear that you're cutting out excerpts to use as evidence to show the jury. Plain as you're not showing the full 55 minutes. We all knew that.
Right.
And it was ruled on before trial that anything Tylee says or Alex says is hearsay.
Mm-hmm.
So if Lori in this interview is talking about what Tylee felt or Tylee said, that automatically wasn't going to be used by the prosecution.
Or she could have attempted to ask Detective Inclan, did I discuss this or this? Asked her, and even the judge mentioned that, look, you could have in cross asked the detective about what was said or what you said in the meeting, and then maybe there could have been some dialogue on that. But there were a number of other instances where she didn't object. So this is just one of those cases where her inexperience, apparently her legal counsel didn't give her any heads up that she should have or could have objected during that as well.
Yeah, and so now we are just waiting for the jurors to report. They are making copies of the jury instructions, and then basically in some time when that's all ready, Judge Boreski will go over all of these instructions one by one, and then we'll talk about the count that she's charged with and accused of, conspiracy to commit first-degree murder. That's going to go on for some time. It is not very entertaining, but you will hear the instructions that the jurors will face, the 12 final jurors that will decide if Lori Vallow Daybell is guilty or not guilty. But we'll get a 1-hour recess for lunch after that is done. So we are getting there, guys.
We're getting there. Again, a packed house in court today. We've already heard from Lauren Clark, who's in the courtroom. All the media is there, local and national. lot of people. We know, I think several of Lori's family members are going to be there. We know that, Kay and Larry obviously following along as well. So it'll be interesting to see if we get to a point where the closing arguments happen. And like I said, I would not be shocked if Lori has, very little to say in closing arguments. But she's had 4 days to write it out. She's had 4 days to help, or get her legal counsel to help her put this out there. This will really be her only, I guess, comments made about the case.
Yeah.
Didn't take the stand. We heard opening arguments, very short and to the point. But we fully expect her to say something like, look, which was her kind of zinger question, and a lot of her cross was, did you ever see me conspire with my brother to kill Charles? Something to that effect. And my guess is she'll end with that, is that no one in court ever saw her in person with their own eyes see her conspire with her brother to kill Charles. I'm fully expecting that to be kind of the last line in her closing arguments.
And she will be told to confirm she's resting her case.
Yes, that'll be first.
As the first thing, and then we'll get into the instructions, and that has happened. So closing arguments is her final chance to, obviously she doesn't have to do anything, it's the state's burden, but it will be interesting to see what she says. She's obviously said in opening statements that, this is a family tragedy, and she said that self-defense is not a crime. And many times she said the evidence will show. The evidence will show. Every sentence started with the evidence will show. But, if you're the jury, yeah, I'm curious to know what they think about all the evidence that the state has brought, and yet she hasn't presented any evidence, which is ironic.
Well, the evidence also showed that she left the scene and was gone for quite some time before anybody called 911.
Yes.
I have a lot of questions for the jurors, because I want to know if they picked up on a lot of that. I thought it was pretty self-explanatory, those little nuances in the case. That she was driving around, or even the nuance that we've talked about, where she comes back to the scene and her demeanor is such that you would never know, or that she just witnessed her husband being shot and killed by her brother. I do want to know if the jury picked up on that, and how that affected their decision.
So a lot of interest, like we've been talking about. Obviously, all the media is there, and we heard via X, Nate Eaton with East Idaho News reporting that they turned away about a couple dozen people from the public, I think, but basically a good amount of people who tried to line up this morning, but already, a packed gallery there obviously includes family members and probably law enforcement. And so definitely a lot of people watching, not just inside the courtroom, but here on the stream. We have nearly 2,500 of you watching the Lori Vallow Daybell murder conspiracy trial as we get ready for closing arguments. Let us know where you're watching from. Give us your questions and comments, and we might read, your questions to the panel of experts that we have getting ready for this lunch recess. But right now, the very important stuff is what we are waiting to get out of the way and get done right and efficiently, so that we get to see, get on this verdict watch. This is a trial that did not last as long as we thought. This is a trial where we thought, not necessarily that we didn't see fireworks or, very fascinating points and moments in the trial, because it's just already unique to have someone represent themselves, especially Lori Vallow Daybell.
Well, we've had a number of people on our stream the last 2 weeks. Not one of them said this was a good idea for her to represent herself. That should tell you all you need to know about representing yourself. Again, you have every right to do so, but it's obviously not recommended, and rightfully so, especially in a crime where you're charged with committing or conspiring to commit first-degree murder. So I cannot wait not only to hear the verdict, but the reasoning behind it. We'll obviously, hear from those who kind of followed this case the last 2 weeks, get their interpretation on it, including Rachel, who was involved in the Idaho cases. Her window or her insight into how Arizona did. I thought, you can speak to this. I thought Boise, I thought they handled everything really well, considering the nature of both cases, Chad and Lori's case. I thought that, they had protocols in place that I don't think they'd ever had before when it came to no cameras, but court audio. and our efforts to get the audio from the
Yeah.
courts each day, and we weren't the only ones. Um, I thought they handled the media frenzy really well. And Arizona's done a great job, but again, they have more experience in doing so.
And they had to have a change of venue in Idaho.
Mm.
I mean, people forget that sometimes where the crimes happen in Fremont County,
Mhm.
between Fremont County, Madison County, small rural area. I mean, pretty much everyone in Rexburg, uh, Salem, they knew what was going on. They driven by Chad Daybell's property. They saw all the media, saw the FBI, law enforcement presence, and they do not claim Lori Vallow Daybell as one of their own. She basically came in from Arizona out of nowhere, a stranger to the state who moved in and within a couple of weeks murders her kids. And then Tammy Daybell is murdered. And so she is definitely, I would, even though she's moved around a lot, was an Arizonan.
Mhm.
She is Mormon from East Valley,
Yeah.
Gilbert and Chandler, and she decided to move her kids and start a new life in Idaho right after the shooting of Charles Vallow. But back to the change of venue, it was just they were not going to take chances with trying to find a jury in both of those cases. So you move it to the biggest county, Ada County, Idaho, and yeah, it was handled well. And obviously, everybody would like to see cameras in the courtroom and see it play out with transparency. But yeah, the way it was done was getting audio every day at the end, and you had probably 4 or 5 hours of audio, and then you'd have to find, you know, what was said, go through what was said, and put stories together and reports. And here we are, fast forward 2 years later, and now we have, camera in the courtroom, just a 30-minute delay. So we've come a long way in this saga, in a case where everyone or a lot of people know her name at least, and sort of know the headlines and what has been said and what she's been convicted of. But now it's up to these 12 final jurors, whoever they will be, to decide if she's guilty of this charge. And then we expect that the court, a spokesperson, will tell the jury that the media would want to talk to them about this right after. So there's a chance that quickly after, maybe not the same day, but there will be some jurors who come out and speak in a more press conference type setting, and we'll be able to hear what they thought about the case, their first reaction. That will be interesting.
Well, we know that the jury in both Idaho cases spoke after court. We have one on the panel later today, but
Yeah,
it took a while, but they were
yeah,
open to speaking. And
that
if
took
you
time.
yeah, and if you've ever listened to them, it's very emotional. They, I think, connected with the case. We should reiterate, obviously, especially with Lori's Idaho case, this involved both children, which any reasonable person would get emotional hearing some of what they heard and saw
Hmm.
in court in Idaho. I don't imagine this case to be as emotional, but we think about all the testimony that was given in this trial the last 2 weeks. Lori's family members, Lori's brother, basically saying, "Yeah, I believe my other brother and my sister conspired to kill Charles." You have Kay Woodcock taking the stand. You have detectives who have been on this case and had already testified in the Idaho trial. So I thought the testimony from the state was very impactful, very powerful. And again, as we said, Trina Kay presented such a case that she didn't need to call her last two witnesses, and that she got her strongest witnesses on the stand. And I thought they delivered exactly what she wanted them to deliver to the jury.
Went heavy with law enforcement. You
Mhm.
had almost 10 witnesses from Chandler Police Department. He didn't have as much like emotional testimony. Only 5 civilians, but Kay Woodcock
Mhm.
was that emotional, powerful testimony to basically convey that she had been made the life insurance beneficiary for Charles Vallow, and Lori Vallow was not happy about it at all when she found out that she wasn't the beneficiary of $1 million, and her struggle to see JJ Vallow again in
Mhm.
her lifetime, to get JJ Vallow to Charles Vallow's funeral after getting his remains, cremated remains, FedEx to her
Right.
by Lori, and how she found out from Charles's sons that he had died, but they really didn't know how he had died. I mean, multiple family members having to go on the internet to find out that Alex Cox shot and killed Charles. Um, yeah, I think we're still talking about it now. And
Yeah.
so the jury knows this very fresh in their mind. We have a lot going on in our archives and our brain for this case, but the jury definitely remembers that. And the overwhelming evidence, I would say, not just on video, But going through those text messages on that final testimony
Yeah.
with Nate Duncan between Chad Daybell and Lori Vallow, there's no doubt that there was an affair, right? And that there was a lot of talk about money. And so during these jury instructions, we're going to find out how they're written, the language, and what the judge says about what is a conspiracy, what is self-defense, what do you need to be involved in necessarily to be part of a conspiracy? Does it entail planning it? And it's probably not a full-on plan and, step by step. If you are knowledgeable and aware of what's going on, I mean, we're clear here that Lori Vallow is talking about Charles as a dark spirit.
Yeah.
We all agree.
Yes. Yeah, we all agree with that. And remember, we had Nancy Joe on early in this trial. She was one of the first witnesses to take the stand to describe Charles the night before he was shot and killed. If you go later in the testimony where, Lori, even in the cross of Nancy Joe, Lori tried to paint it as, oh, well, you're a woman who dates married men. You good with
Mhm.
that? But then later we hear that Lori has already been dating and kind of,
Mhm.
has already moved on from Charles.
Mhm.
And for the prosecution to present that in that order, I think they wanted that part to stick with the jury clearly. I think
That was
that
a hammer. I
that
mean,
was.
that's a home run because in opening statements, they do bring it up.
Mhm.
Trina K brings up, that she did this to be with Chad Daybell. She wanted the money. She wanted to be with Chad Daybell. But they weren't hearing the stories yet about Lori and Chad. And so for Lori to cross-examine this witness who went on one date and basically criticize her for
Mhm.
dating a married man,
Yeah.
I think when the jury sees all the text evidence a week later, or whatever it was, I think it was about a week after Nancy Hancock went on, I think they automatically lose trust in her as the
Yes.
defendant because they're going to say, well, you went after this lady, but you were already in this relationship the whole time with
Mhm.
Chad. Uh, we don't trust you. That's what I would assume, at least for some of the jurors.
Right. And again, they didn't hear all the other outside stuff after that and what she was doing and going off, getting married and all that stuff. I just, yeah, you're right. They hammered
All
it
right,
home
back
at
on the
the
record, State
end
of Arizona
and it
versus
stuck.
Daybell, CR 2021-0017.
Oh,
All right, we are back on the record.
The jury is not present. All right, please be seated. The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions. Are we one? Oh, nope, we got it. Okay. Jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. One, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. And two, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, one, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and or two, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1. Solicits or commands another person to commit the offense, or 2. Aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3. Provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
What?
Trying to get my eyes a little bit of a break by looking down.
Taylor will be joining us a little bit later in about 15 minutes or so. But I want to introduce you all to our esteemed panel of legal experts here, and every one of them have different insight and perspective. Now, Rachel Smith, special prosecutor in the Idaho trial against Lori Vallow Daybell. She's the founder of Smith Law and Consulting, focusing on assisting prosecutors nationwide as well as other civil matters. Her prosecution work includes appointments on sensitive and complex litigation. Taylor Larson with Ellsworth Family Law. He's been practicing here in Arizona since 2016. He was the former attorney for Charles Vallow. Charles Vallow, the victim in this case, who confided in Taylor as he was going through marital issues with Lori Vallow at the time, wanted her to get mental health and mental help for her mental health, I should say. Taylor Larson helped Charles file those divorce papers that were just, I mean, so fascinating to read now, years later, as he was asking for help and saying that there were major concerns with his then wife. And we have Susan Constantine, body language expert, jury consultant. She has covered so many trials. If you are being deceptive in any way, she will find out. Trust me. We have Tom Evans, juror number 18 in the Lori Vallow trial in Idaho. I mean, he didn't expect for his life to take such a turn, but he was sitting in that jury box, but he ended up being an alternate juror even though he heard all the evidence, and he ended up writing 2 books on the Vallow Daybell saga: Money, Power, and Sex, the Lori Vallow trial, and Chad Daybell, The One, Mighty, and Strong. And finally, he's a retired Maricopa County Superior Court judge, a former prosecutor with the Maricopa County Attorney's Office, and former U.S. Attorney for the District of Arizona, spending decades in the courtroom. He is the judge, our judge, Mel McDonald. Thank you guys for joining us. We appreciate you. Closing arguments. I mean, you have to be a little bit hyped up for this. It is a serious matter, but we are going to see how Lori Vallow Daybell somehow, is this her testimony in some way? She decided not to present any evidence. Rachel, let's start with you. No surprise, she has declined now 3 times. But what do you expect to see as we get into closings in just a little bit?
Well, it all at this point kind of all comes down to the jury, right? And we're going to see both sides try to put forward their point of view to the jury. We're going to see how well jury selection turned out at this point. We also, we are going to see Lori take the time to try to sell what she believes the jury needs to hear. Lori's going to put forward her point of view, and I think this is where you're going to see her try to testify. Lori's going to have the last word if Lori can have can get it in, and then we're going to see the prosecutor put forward and try to get out and help the jury understands very complex legal concepts, conspiracy, self-defense, some of the hardest legal stuff out there.
Now, in opening statements, Lori again and again said the evidence will show, the evidence will show, and the evidence will show that self-defense is not a crime. Now, she didn't present any evidence. Judge, what does the evidence show in this trial?
The evidence is compelling. If I were the prosecutor making the closing argument, I would lay out, starting from the beginning of their relationship. There are smoking guns after smoking guns in this case. The correspondence between her and Chad, the hypocrisy of some of the accusations and cross. I would make a point, if I was the prosecutor, to point out the things which Lori said the case would show that didn't. She opened that door. She said it will show this, it will show that, and she didn't show anything other than probably a lot of hypocrisy, and clearly showed that she was bright, intelligent, articulate. I think the case will go to the jury later this afternoon. I would be shocked if the jury is out beyond tomorrow.
Now, this has lasted for less than 10 days, really. Let's set the scene for you. We had dozens of people line up this morning to get in. People were turned away. We've got local media. We've got national media. We know the type of publicity and attention this case has garnered through all the trials. We've got a reporter going live right now outside the courthouse, and the jury's just getting a lunch right now, getting ready to make a huge decision. Tom, that brings us to you. You sat in that box and you listened to all of the evidence, and even though you weren't in that deliberation room, just what was it like for you to hear closing arguments in that trial in Idaho?
Yeah, it's hard to sit there. I hope that this jury stays awake actually after those jury instructions, and I think the closing arguments will be a little more exciting, and maybe they'll wake them back up.
Yeah, obviously the instructions are very, detailed and complex. But closing arguments, I mean, what stood out to you from the prosecution? Obviously, and Rachel was in that courtroom, but just what stood out to you in closing arguments, whether it was from the state or the defense in 2023?
I think that case, it was pretty cut and dry. There was a lot, just a compilation of evidence that added up to only one conclusion. So my mind was pretty well made up by that time before we ever heard closing arguments.
Susan, what are you looking for in the body language, the demeanor from the so-called Doomsday Mom this afternoon?
So she's kept herself pretty well in check. I think we could all agree with that. A few times of being snarky, a little condescending, sarcastic at times, argumentative at times. But now the ball's back in her court, so no one is going to be asking her any questions. So she's going to be totally in control. What they're going to be looking for, in my personal opinion, is she showing any sort of remorse? I mean, her husband had died. He was killed. So is she going to be showing any genuine remorse whatsoever? The things that I would be looking for is her overall demeanor is so flat. I think that in itself speaks volumes, because it's not so much of what you see, it's the absence of things that we don't see. So the fact that she's not showing any sort of genuine concern, emotion, all of these are all the subjective part of it, right? They're subliminal messages. The other part of what I think they'll be looking for is how well she's able to articulate. She's very organized. She's very precise in a lot of ways, in her own way. What does that tell them about her personality and the fact that she could be a part of this conspiracy to do what allegedly she had done? Because this in itself takes a person that's very smart, very methodical, very organized in her thoughts. So in that respect, it may play against her, but who knows? All it takes is one juror, right? And I think we'll all agree it just takes one juror, a holdout, and here we go again.
And I think we can all agree that it would be shocking if she did show any emotion regarding Charles Vallow, if she said that she loved him. But we know that she has already said this is a self-defense claim, and that it's almost like Charles was the villain. She makes him seem to be in her case. So Taylor, I gotta ask you, waking up today, you've been down this road, this journey for 5 years. You were in that office when Charles came to you and said that he had problems with Lori. He told you that if anything happened to him, it would be Alex and Lori. And now here we are today for closing arguments. What is it like for you, full circle?
Yeah, it's, Justin, it's exciting to finally be at this point in this saga that's drawn on for, like you said, 5-6 years now. But it was in this office, this that I'm sitting in right now, where he foretold of how he was going to die, and that it was going to be, Lori and Alex who did it. So to finally be here, to finally, hopefully get some justice for Charles, it's a great moment, and I'm hopeful that, like the judge said earlier, it'll be a quick deliberation, and that we'll get to close this chapter here today, and it won't drag on to tomorrow. But even knowing that, if it does drag on to tomorrow, I don't think it'll be long for tomorrow. I think it'll be a shorter, a morning verdict. But remaining hopeful, and excited to see closing arguments. Excited to see if Lori's going to inject any of those emotions that you talked about. Will we see her put on the theater that she kind of put on at the opening? But I don't expect her to, because of the way that she's handled herself anytime she's talked about Charles in this trial.
Now, during instructions, the judge mentioned this statement that sort of when, like, even if you are at the scene of the crime, it doesn't make you guilty of that crime or that conspiracy, trying to explain that we know she was inside the home when Charles was shot and killed. She left the scene. But Rachel, if you could take us into that conspiracy to commit first-degree murder charge in that language, you think something like that, the jury knows she went to Walgreens and Burger King, but it doesn't mean that she had to be the one to call 911 and do CPR on Charles, even though many would think you should do that for your husband.
You're absolutely right. Jury instructions of conspiracy can be very confusing. We will expect the prosecutor to kind of walk through language. The defense is going to focus on some language the judge used, which is called mere presence. Merely being present doesn't mean you're guilty of a crime. The prosecution is going to focus when they discuss those instructions on contribution to the idea, the planning, the agreement to have someone killed or to commit an act. So it's going to be about her contribution, her encouragement, her aiding of Alex before the act of murder, and then the consciousness of guilt she showed by her actions later. So those instructions were legal definitions that the jury will have to wade through, but we can expect, like you focused on, the defense is going to focus on merely being present when someone is shot. Doesn't make me guilty of conspiracy. And we're going to hear the prosecutor talk about those texts. It's all coming ahead to this week. Stay close to me. You'll be like Nephi. Those statements which show the planning, the intent, and her aiding and encouraging Alex in murdering Charles. So the prosecutor's job will be to take the legalese, all those legal instructions that courts spent years working on, and translate them into the evidence. And I think we're going to see that from Trina Kay. And she opened with the language she needed, which is stay close to me. It's coming to head this week.
Judge, what are you looking for in Trina Kay? As she's going to go an hour plus, and I assume that she's going to have some visuals to bring back up on the screen. You've been in her shoes.
Yeah, I think you start when you look at the Dave event, there are facts that are absolutely overwhelming. Mind you, to have your husband shot in front of you and you take your kids and go to Burger King or wherever they went and then to buy sandals, you don't call the police, you don't do CPR. Any parent on the earth, if your child witnessed this, and Tylee was there, you would be traumatized. And yet you look at the videos of her at the scene from the body cam, smiling, indifferent. That is the starting point. And then you build the blocks before the relationship with Chad Daybell. I would have given $1,000 to have a video of her face when she found out the $1 million insurance wasn't coming in. These factors, piece upon piece, are going to be overwhelming. That's why, in my view, yeah, the instructions can be challenging. They can be cause some confusion, but in this case, no. There are too many chances that she can't escape. And interesting enough, I come back, the only emotion we ever saw from Lori was in the opening statement. With her daughter there, with this cold-blooded nature of this killing, no emotion. I suspect we'll see some more tears as part of the performance in the closing, but she cannot get away from the evidence. It will be a speedy verdict, and I'm convinced it will be a verdict of guilty.
Hey, Tom, you were in the courtroom in Idaho for sentencing as well. You wanted to be there to see Lori Vallow Daybell. She was sentenced to 3 life sentences for the murders of J.J. Tylee and conspiring in the murder of Tammy Daybell. Now, in her allocution, she does get religious and she does get emotional when she talks about her children, mainly Tylee Ryan, like Judge Mel mentioned. Do you think we could see some of that in her closing arguments, like she will use the name of Jesus Christ and, she's just a religious person? Is she going to testify something like this?
Yeah, it's very possible. I mean, this is her opportunity, right? She could try at this point to convince the jury that she is a translated being. I'm not sure if she's going to do that. So far, she's been back off of that. But if she's ever going to do it, this is the time. So we'll see.
When you were listening to the evidence, what weighed out more heavily to you, religion or the money element?
In this case or in the first?
I would say the first case. Obviously similar as far as what the motives are being described and alleged by prosecutors.
I think for me personally, it was more, it was less the money. It was part that, but I think it was more just her crazy religious ideas. Yeah, I would have to say more of that.
Susan, I gotta ask you, and I'll ask the other prosecutors and Judge Mel as well, but as far as the jury, how much leeway they get in discussing their schedule? I think everybody is very curious of what we expect this evening. But by the time they get the case, it's probably going to be 3 p.m., 4 p.m. Pacific time. Who knows?
Well, the first thing they're going to do is they're going to select a juror foreperson. That's what they're going to do when they first get into deliberations. Oftentimes, they take a first ballot vote, to see how far they away from one another. So it could be very quick. We could see where they are as far as their baseline is concerned. Do we have a few people that are undecided? Sometimes, they set the rules. So there's no set of rules because they get to decide what the rules are and how they're going to do it. So how they end up in that procedure, the only way I can give you a description is through what I've seen in mock trials and focus groups, and they're all different. And sometimes they get really argumentative when they're in there, right? That some you've got like the Hatfields and the McCoys. Sometimes you have a division, but it really is based on that juror foreperson and their leadership qualities to be able to bring them together and to be able to make every single one of them be feeling that they're heard and they're validated. And then, of course, if they've got someone that is what I call a stronghold or someone that has a varying opinion, then they've got to go back into the evidence. And then what they do is they discuss it. But, it's really interesting. And I'm sure that all of you, my panel, has seen it behind the scenes. And I've conducted focus groups and mock trials. And it's not a clear cut. This is how you do it. And we all do it the same way. Every single case has its own nuances. But I think that they're probably going to get back there and go, you guys, this is like the craziest thing I've ever heard. What do you think? I'm sure that there's going to be a release because they haven't been able to discuss this case at
That's
all.
true.
And to the point, whether it's the money or whether it has to do with the crazy story about the zombies and all of the kind of stuff. If I were a juror back there, I would be kind of stuck into this whole zombie thing saying this person is absolutely nuts. I think to the judge's point, I think that we're going to see a verdict come back very soon. I don't need, it may even happen. They may stay later. A lot of times when they get started, they want to just, if it's a first ballot vote, most are coming up with guilty or versus not guilty, that would determine whether they're going to go into the next day and go home. We don't know. That's the thing is about juries. We just don't know. We think we know. All we can do is do our best. But what happens behind closed doors has always been a mystery.
Yeah, to be a fly in that room, that will be something. And also to know the makeup of that jury. Every person is different, so we don't know exactly what we're going to get. But Rachel, take us back to 2023. The jury gets the case. And I remember they got like pizza for dinner in Boise, Idaho, and then they end up going home for the night. Just if you could, were you surprised that, do you think it was a quick verdict or did it take longer than you thought?
In my experience, I thought it was a quick verdict. I think there were some on the team who were depressed that it took as quote unquote long as it did, but I thought it was a quick verdict. They had multiple counts. They had weeks worth of evidence to think. And it doesn't surprise me when I hear Tom say going into closing argument, several of them had their mind made up. That most juries, if the prosecution has done their job going into closing arguments, most of them will have their mind made up one way or another. So no, back in 23, I thought it was a relatively quick verdict. You got to remember there were 3 sets of crimes they heard about and had to consider. They also had to consider the overall conspiracy spanning a year plus. So the amount of evidence that existed in Idaho and what was at stake was a lot greater than this jury has. This has been kept very narrow, very focused on Charles. If we don't have a verdict by tomorrow night, then there's something going on in that jury room that we're concerned about. I agree with the judge. The prosecution's done it. The evidence there, it's very clear. So we should have a quick verdict.
Hey, Taylor, I got to ask you because people watching have asked, why weren't you brought in as a witness for the state? I think your insight has always been, I mean, I've been talking to you since 2020, your insight into what Charles was going through. I mean, do you think you're a lawyer too? I mean, why would they not, give you a call?
Yeah, I've been curious about that, Justin, because I was waiting for someone to call from the prosecution. I was waiting for, even law enforcement to call me. Like we talked about a little bit last week, I don't know if it was the attorney-client privilege that kind of scared them away. But, like I said last week, most of the stuff was waived because Charles told me, if this happens to me, it was Alex and Lori and tell everybody, because I won't be here to tell it. And, it's interesting. I saw a lot of watchers are wondering why wasn't Charles's body cam brought in that we're seeing on the screen right now. And obviously hearsay kind of keeps that out. And so you have to bring in someone, and they could have brought in me to say, hey, this is what he told me 6 months ago. And he foretold of it, but that, I don't know if that would be kept out as well. But yeah, it's a question that I've always had on my mind throughout the saga of the last 5 or 6 years.
Well, we're glad to have you on as our witness, taking the stand for us every day on the panel, Taylor. All right, we've got Benjamin Taylor on the panel on deck, criminal defense attorney here in the Phoenix metro area. Benjamin, just your thoughts going into closing arguments, what you expect to see from either the state or Lori Vallow Daybell.
Lori Daybell has to hit a home run. She has to look at those jurors in their eyes and hopefully convince one or two. As we talked on the panel earlier, this is going to be a tough case. It's probably a quick verdict. However, if she can convince one juror, just one juror, she just needs one, right? So maybe she's been in this jury for the past couple of weeks. So he could probably key in on maybe one juror is nodding towards her. Maybe one juror is smiling towards her. Who knows what's going on in there? But she's probably going to key on that one juror or two jurors to hopefully convince them to go back in the jury room and say, hung jury, or I can't decide, I'm confused, and I can't, complete my decision here. And we'll see what's going to happen based upon the jurors' questions. The jurors' questions, if they have questions during this deliberation, is going to, we'll see what way they're leaning towards. But Lori Vallow better try to hit a home run by convincing one or two jurors to have sympathy for her or something in order to get a hung jury in this case.
Or more like hit a grand slam. I mean, have you done that? I'm assuming in the courtroom you build a chemistry with one of the jurors or couples. Maybe it's just a smile or not. I don't know. But just, Benjamin, is that what you're talking about? And then you zone in on them with your last chance to speak?
Yes. So every time Lori Daybell has been done cross-examination, the jurors are right there to her right of her. So she can look and see how the jurors are reacting to her questions, how they're reacting to the witnesses' statements. So if you see a juror smiling at you or nodding towards you, then maybe juror number 5 is on my side. Maybe juror number 8 is on my side. But if you see the jurors when they're like turning their head or going like this, or maybe even falling asleep. In some cases, when the evidence or they don't believe you, some jurors will just close their eyes and just like, you're done. And that happens in real life every day in trial. So Lori Daybell better have been paying attention for the past 2 weeks and looking at what jurors might be nodding at her, what jurors might be even having a glimpse of even liking her, in order to try to, like you said, Justin, hit this grand slam, because that's what she's going to need. She's going to need a grand slam in order to even have a chance of getting past this guilty verdict and trying to get a hung jury in this case.
Money Mel, you've got to have some stories from the courtroom. Looking at those jurors, you got to give us something. Is Benjamin speaking the truth here?
Let me pose this one question. Look at, if you're a juror and you're trying to see whether there's innocence here, looking at Lori Daybell, what is one fact that you can come up with that is favorable to her defense? In other words, we're talking about a jury hanging. It can't be her emotion of the day. It can't be that she's distraught. It can't be that she doesn't call 911. It can't be because the religious, he was possessed with demons. So when you look at the possible juror that might hang the case up, the problem with that is there's nothing to hang it up. The only conceivable thing that helped her is the delay in getting the case prosecuted. And I think part of the problem was Kylie, on the day of the incident, apparently talked to the police. Lori apparently had her trained, and Alex did have a minor wound on his neck. But the fact of the matter is, when we talk about, well, yes, a jury can hang it, but to hang it, there's typically got to be something really significant to hang it on, and there's not. Her despair when the $1 million is going to somebody else, eliminating people left and right from her life that are a problem. I've got to believe the jury's going to wonder, where is Kylie as a witness in the case? She was in the house, but Lori didn't call her. Sure, she doesn't have to, but why? the reason I think the chances of a hung jury are remote is there's nothing, absolutely nothing, that's been brought out in this trial that's favorable to Lori Vallow.
Tom, when you were in the courtroom these past 2 weeks, did you see any? I mean, how would you say the jury reacted to a lot of this overwhelming evidence, specifically the religious stuff, the dark and light spirits?
Yeah, I don't think they reacted too well to all of that. But so the way Chad and Lori operate is they throw out an impossible premise, right, and see who falls for it. That's their tactic, and then whoever falls for it becomes a follower of theirs. And so I'm guessing, I don't know what the number is, it's probably 1 in a million people would actually fall for that. And she's got a pool of 12. And one of those people has to be on that jury for her to be able to win this. And it's possible, it's just really unlikely.
Was there a witness that really stood out to you throughout this trial out of the 90 witnesses, Tom?
I think just like in the trial in Idaho, it's not one witness or one thing that does it for you. It's an accumulation of all of it.
Yeah, that's Susan. What would you say about that for a juror's perspective?
Well, actually, can I kind of back up a little bit? Because I'd really like to speak on what we would be looking for in the juror that are either on board or off board. Do you mind if I speak to that?
Yeah, sure.
Okay, so some of the things that I look for when I'm in trial and I'm watching the jury is those areas of these little micro expressions. And I know we've heard about micro expressions in the past, but there are these very, very little subtle micro expressions that just kind of leak out, and they also go back to normal very, very quickly. And what that's doing is it's telling me subconsciously how they're actually feeling about a specific witness, parts of the evidence, how they feel about her. So what I'm looking for are areas of what, if you can see my face where my eyes all of a sudden become slightly narrowed, right? Or maybe my eyebrows lift and I'm surprised. Maybe I might even show a little micro expression of disgust and maybe a contempt, facial expression, eye rolling and contempt. So there's these little minor little subtleties that I look for that's telling me about emotions and cognitions. And then what I do is I record who's doing what when. And is there a pattern within specific jurors that are actually doing it? What are they hearing? Who's testifying? And how they're actually feeling about it at that moment? Because that's the stimulus, that's the probe. How are they immediately responding? So those are the kind of things that I would be looking for that would kind of give me a preempt on how that jury may be thinking, and how that would potentially end up as their vote at the end of the day. So also I'd like to speak to about this, maybe a holdout juror, as a judge spoke about. I sat all the way through the Casey Anthony trial. I covered that case from beginning to end. And there's also, I never thought for a million years that she was going to be found not guilty, right? But also keep in mind, she is in front of that jury the whole time, speaking, and she's demonstrating, and her presence is known. There is something to be said about that familiarity, where a juror becomes immune to that person and seeing them as far as guilt or innocent. So I don't think that we should downplay that. I think the judge is correct, but there's also a phenomenon too, where I saw in the Casey Anthony trial, like how in the world could that jury possibly think that she was not guilty? And the reason behind it was because she was faced directly in front of that jury the entire time, and there was a sense of familiarity that happened there.
Interesting. Rachel, I want you to take us into your courtroom at the time in 2023. Did your team huddle up after certain days and notice that jurors were picking up and starting to understand this very complex case? Did you guys have notes on that, or was it just focused on the witnesses?
No, we did as a team, or more specifically, Rob Wood, who did the closing argument, myself, and a couple of people, we sat down and said, okay, what did the jury seem to react to? Are we in danger of overdoing it? It became very clear to us that the jury had a visual and physical reaction to the pictures of both Tylee and JJ. And so that became a choice. Do we use those images again and walk through as much of the science about how they died as we had planned. And so there was some concerted discussions on what should be caught out of closing arguments, because you don't want to be perceived as overdoing it. And the jury's reaction had a role in how much Rob covered and how much the team asked Rob to cover in closing arguments. So absolutely, we pay attention. We would look at the jurors to see how they were responding to certain evidence. I think sometimes that worries the jury, like, why are they looking at us? You're trying to get a gauge. How far do you go? What do you cut out and what do you key in on? And Rob shaped a lot of his arguments around how do we think the jury will see this and what makes the most sense for helping a jury see and understand how and why a mother would participate in killing her children and killing her boyfriend's wife.
It's a very emotionally heavy case, because I just remember being in that room for the graphic evidence that was shown. You could hear people crying. It was quiet, and it was just, you could feel that heaviness. It's something that you don't forget. This case is a little bit different. Obviously, still a man who's been shot and killed and gunned down after going to pick up his child, JJ Vallow. Rachel, I want to ask you this. Earlier today, Lori had issue with the video that was presented in court regarding her an interview with Chandler PD, and she said that it wasn't the full interview, and confirmed that it was excerpts. Is that a common thing? The prosecution had to get rid of portions that included hearsay regarding Tylee Ryan, and she was picking at this for some time.
It is not unusual that the defendant will object to evidence being redacted and not redacted. Chopped up, they'll sometimes say, and they will sometimes argue, well, that's not telling the whole story. That's not providing the whole narrative, or that it's editing the evidence. Had she had a defense attorney, those objections would have been raised before the exhibit was admitted. They would have been raised during her cross, and then perhaps most judges I know that if there's a debate between the parties about what comes in and what doesn't, the judge expects the parties to either work it out or you have a hearing on what else should be there. So the judge was very clear with Lori, look, any of these concerns that it's not the whole statement or it's not the whole story, the whole exhibit, your time is run. You're out of time to change it. That should have been brought up on cross. It's example 5001 of why Lori Vallow is her own worst enemy.
Yeah, Benjamin, how many times did you see opportunities for an objection where you're watching and you're literally saying it out loud as a lawyer?
I mean, tons of times when I was watching it, I wanted to say object. And she does have an advisory counsel there who's sitting next to her. I'm sure who's like, maybe nudging her arm a little bit to say object. But ultimately, Lori Daybell, she is her only, she's the main attorney. She's her only attorney. And she has to be able to articulate and write briefs and go in front of the judge and jury like any other licensed attorney in this nation. So unfortunately, that's what everybody on the panel has been saying. If she had an attorney, this case might be a little bit different today. Evidence being presented, cross-examination, but she's her own worst enemy by not having an attorney in this case.
Judge, if you were in the defense's shoes, how would you have been objecting throughout this trial? Where would you pick at?
One of the things that's important for your listeners to realize, the case that's being tried in front of this jury and this judge is only a small piece of what's really happening. There are appellate courts, there's the Supreme Court, there are federal courts. These cases often go through after that. That's why you have a court reporter there. That's why you make a record, because eventually that record will be reviewed. And as everybody on the panel has recognized, it is catastrophic when you represent yourself and points of error can come into the record that you don't object. The law is clear that you thereby waive the ejection. So, for example, hypothetically, if there were parts of her interview that really should have been in or should have been objected to that could have constituted error, you make a record at the time, not only for this judge, but for the Court of Appeals, the Supreme Court, the federal court, sometimes all the way to the Supreme Court. That's why a person that represents themselves has a fool for a client. If you don't have a legal background, you don't recognize it, the advisory council cannot help her. And so the bottom line, all of these things work against her and eventually, I think, create a record that will be sustained not only with the conviction in this case, but by the appellate courts.
We have about 8 minutes left until the jury comes back into that courtroom. Taylor, what do you think has been the most damning evidence against Lori?
I'll go back to opening statements, and I'm sure we'll see it a little bit in closing statements. But the most damning thing for me has been that they planted the bat on the wrong side of Charles. You know, that he was left-handed, not right-handed, and the gap in calling 911 after, you know, and the second shot. Those are the three things that really stuck out to me, and really kind of make me emotional, knowing that, you know, Charles may have survived that first shot if it really clearly was self-defense, which we all know it was. But I think that those three things are going to really true for the jury.
Susan, you brought up the Casey Anthony trial and how the jury just became, they got to know her. They got to see her and feel her as far as what, you know, she was like. Do you think that could be the case because Lori has been acting as her own attorney, you know, talking to witnesses, talking to the judge, wearing civilian clothing?
I think it can go both ways. They're gonna, you know, they're gonna either hate her, or they're gonna be some people say, you know, she's got a lot of gall to be able to do that. But I think, you know, it depends on how each person processes that information differently, and that's what we have to really understand about jurors. You know, everybody comes with their own backgrounds and their own beliefs and so forth, and then it's how they actually are processing that information. But for me, what I'm seeing is the fact that those jurors are saying, no, Kylie, not the son is not there. The visual impact of her smirking and smiling, her casual nature of after it happened, going to the store, getting the flip-flops, all of this is a visual presentation. 65% of jurors are visual. So when you think about how many people are visual, that means 7 people on the jury panel are going to be seeing these videos, and they're going to say something is really off. And I would assume that they would know that an innocent person does not act that way after their children's father was just murdered, especially right there in front of her.
Rachel, if you're Trina K, what are the visuals that you would want to show to the jury as you go through this hour of closing arguments?
The visuals are the things that Judge Mel has highlighted, Susan's highlighted. It's her conduct afterwards, her laughing, hi neighbor, after the death of her husband. You're going to present the picture and the angles and the trajectories of how Charles was shot, because that evidence is powerful evidence of premeditation. There's no reason to stand over somebody and shoot them a second time in a downward angle in self-defense. So you're going to see the visuals of Lori's attitude and demeanor, which reflects her desire for Charles to be dead. You're going to see the evidence that shows us it was premeditated murder, not self-defense. And then you're going to see the visuals from the text of the motive and the reason why she wanted Charles gone.
Yeah, I put this out on X this morning. When do we get a verdict in this trial, tonight or tomorrow? Majority, 56% people believe it's going to be tonight. Tom, what do you think?
It's hard to say. I think it could be, but I also think that the jurors are going to go through very carefully the instructions. That's why it went overnight in Lori's trial, is they wanted to be real thorough, go through, and the instructions were complicated, and that's just how long that took them. So I don't know how, you know, this is a simpler case, obviously, so maybe it'll be a little quicker, but we'll see.
Okay, how about you, Benjamin? Benjamin? Susan, what do you think?
I think that they may go home today, get a good rest, come back tomorrow morning if they aren't already still ready to go and want to go home and get this thing over with. But I think tomorrow they may take a fresh start at it, and then we'll get the verdict either late tonight or tomorrow if they decide to stay late. So I don't think it'll go beyond tomorrow.
Taylor?
Yeah, I've been kind of worried because my schedule tomorrow, I have two court hearings tomorrow, but I was able to clear it. So I think that tomorrow morning is that's my prediction.
So they'll get refreshed tonight, and that's what you're thinking. All right, how about you, Rachel?
I agree with the others. I think they'll, in my experience, jurors are very conscientious. If they've made up their mind early, they're going to want to make sure that they don't send the wrong message. They're going to make sure they show they're thorough and conscientious. They're going to go through those instructions. They may want to get a good night's sleep and face it tomorrow morning.
All right, Judge Mel?
I think it depends a lot on when they get the case. If they got the case at 3 or 3:30, I would suspect that they may want to stay late. Clearly, and I think from the standpoint in the juror's heart, we don't want to walk in and walk out in 10 or 15 minutes. We want to let the world know that we discussed it, that we deliberated it, that we went over the evidence. But there's nothing really that's going to create grave challenges. So I think if they get it by 3 o'clock or 3:15, there's a chance it could be tonight. But I think probably if it's late, I would agree probably tomorrow morning. If it goes beyond tomorrow, I would say there's a problem, but I can't conceive of a problem in this case.
Yeah, if it goes into tomorrow afternoon, yeah, I mean, we may be thinking what's going on in there. You all, thank you so much for being here on Closing Arguments Day. We appreciate you, and we'll see you in a little bit. Thank you so much to our panel.
Thank you.
Thank you.
Thanks, Justin.
That was quite the conversation there, and as long as these jurors are in that deliberation room, we will be here and we will have our panel back on as we talk through the day after they get the case. It is going to be interesting.
It is. I want to go back to something Ben said that, we learned that the jury can ask questions, right? As Susan pointed out, this is the first time when they deliberate later this afternoon. That'll be the first time they have a chance to talk amongst each other. Again, great to be a fly on that wall. Then they'll have an opportunity to submit questions after closing arguments if they choose to. The judge will then answer those as best he can. I would wonder if that's a window into what they're thinking and how much we can take from their questions after closing arguments. They've asked a few questions throughout this trial, but I think if we were to hear more questions after closing arguments, I wonder if that gives us more of a window of how undecided are they? What do they want to clear up?
Yep.
And again, is that something that could leave the window open for one juror to say, look, I didn't think that the prosecution did enough to prove conspiracy, because that's what they're deciding. So we'll have to wait and see. I would think, depending on how late they get it, maybe they do want to spend the night and think about it and come back, as Rachel said, fresh in the morning and ready to either deliberate some more in the morning to make sure everybody's on the same page, or if the foreman feels like, look, we're all in agreement. I think that we could see that as well, because 2 weeks doesn't seem like an eternity to a lot of people, but when you're in a courtroom for whatever it is, 7-8 hours a day with 13 strangers, 14 straight, I just, that could play heavily and be like, look, let's go home and sleep on it, even if they think, yeah, we're all in agreement, but why don't we just come back first thing in the morning? So we'll have to wait and see. Closing arguments, though, are first up, and those will be interesting to hear.
We've been waiting for this. So in a minute or so, they will be getting into that courtroom. You guys will get to hear those closing arguments in about 30 minutes after that begins, and we'll be tracking it. But that was quite the conversation with our experts, and I'm telling you, we will be on all day long until the jurors go home. When we get official word that they're going home and recharging for the night, we'll call it. But stay here, subscribe, hit the bell. You know where to be. We are not turning this off anytime soon. 3,300 of you watching the Doomsday Murder Trial for closing arguments. We will see you in a little bit.
I was muted. It's probably good that I was muted because I said something. Well, yeah, so we're having a break right now uh, because court has come back and Justin needs to go back in the courtroom, I'm guessing, because Justin is in the courtroom also. So, yeah, the courtroom is back in session. I'm going to check Twitter and see if we've got any news. Let's look and see if Tracy. Okay, let me get over here. Nope, nope. So, let's see. I thought I saw a comment by Trace. Let's see, live chat. Well, I thought Tracy said something and I'm trying to find it, but let's see. Well, I don't know what I have done with Tracy's comment that she just. Trina's up, Tracy says. They're all seated and Trina's up. So let's see here. So Justin Lum is not okay. Justin says, okay, share this instead. Justin Lum says that the judge rules that one exhibit is going to be submitted for appeal purposes that won't be evidence and for the jury to collaborate. Won't be evidence with jury for deliberation. That doesn't make sense. And okay, the judge rules one exhibit is going to be submitted for appeal purposes. Okay, I'm guessing this is her video she's been whining about. I did not curse. No, I noticed that. That's a good thing. So that was from Justin. And let's go back and see what else he says. He says that jurors are ready to come in for the closing. Okay. Let's see what Nate has to say. It says that Lori is at the defense table chatting with her investigator and drinking from a bottle of water. Trina Kay, her paralegal, and Detective Nathan Duncan are at the prosecutor's table. Kobe Ryan and his wife Kelsey are in the courtroom sitting next to Kay Woodcock. Judge is on the bench and he mentions Lori requests to have the exhibited admitted for appeal purposes only and it won't go back to the jury for deliberation. The judge asks for the jury. So this is this video that she's been whining about that she is finally getting in, I guess. Let's see. So that was from Nate. And Nate had another comment. He said that Trina Cray approaches the lectern and stands directly in front of the jury. July 18th of 2019 is just 7 days after this defendant and her co-conspirator shot and killed Alex. That don't make sense. Just 7 days after this defendant and her co-conspirator shot and killed Alex Cox, the defendant, texts Chad Daybell. Her words. Tell us she was involved in this killing, Trina says. Motives were Chad and money. I just got the letter from the insurance company saying I am not the beneficiary. It's a spear through my heart. Who do we think changed it? So that's how Trina starts. I'll put that in the chat. Oh, Lord. Okay, and so back over here. So let me look at our chat because Trace is saying that Adam knew he was right. Christina knew she was right. Trace says they're bringing up the drugging of Charles. Trace says that Trina K is way more animated than you've seen her before. And she's off to a great start. Oh, shoot. Y'all, I thought I was sharing this. Am I sharing it? Let me see. Yes. And they brought up Nephi. Okay, let's see if Justin has what say Justin. Justin says Trina K brings up Adam's text to Charles saying they're planning something when Charles arrived at Lori's home where Alex was. And then Trina K brings up Nancy Joe's testimony and how she was told Charles to let Lori know he changed the beneficiary on that life insurance policy. I sure wish he had done that. Let's put this in the chat. That's a good one. That's from Justin. Oh, no, I guess that was. Also, here's another one from Justin. Justin says the evidence that has been presented, the evidence that is presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit murder, says Justin. Okay. Now, Trey says she's going to split it into three things: motive and timeline, and then instructions. Then justifications. There are none. She calls it the execution of Charles Vallow. That is so good. That's profound right there. I'm trying to. Oh, I'm in the wrong thing here. Trey says there's a discussion of cheating with Chad and Charles Contact and Tammy. Well, she's really telling it. Let's see what Nate says. Okay. Trina tells the jury that anything Lori says during her opening statement was not presented in. Trina tells the jury that anything Lori said during her opening statement was not presented as evidence in the trial. Trey says they talk about whenever Adam and them were coming to town. Trina puts the timeline on the screen and details the premeditated execution of Charles Vallow. June 29th and 30th, Charles learned of Lori's affair to Chad Daybell. Charles emails Chad about the affair. Charles emails Tammy about the affair. Charles tells Adam about the affair. On June 9th, Charles tells Adam he's booked a flight to Phoenix and Alex is about staying with him. Chad and Lori talk 3 times. Okay. Let me get back over here and see what Tracy's saying. Tracy says she got up the PowerPoint. Okay. Hang on. I don't think they're back in yet. Fox is not back up, and neither is it. I know they're back in court, but I don't think that it's streaming yet. Is that the right thing? No, that's wrong. So, all right. So we're going to go back over here and see what's going on here. Nate says that at 7:22 p.m. on July 9th, Lori texts Melanie B. You can't go tomorrow. It's coming to a head. This week will change everything. Call me. Lori also texts Adam. So the plot thickens. Call me when you can. Get sleepy. You can get. I need you to come get the stuff at your house tomorrow. Lots to do. Wonder what stuff they had at the house. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I'm told, and so will you. Alex told Lori that they talked for 56 minutes on July 9th. The next day, Chad called Lori and they talked for 149 minutes. Lori is also texting Melanie about a mission to distract Brandon by faking sick. Adam arrives in Phoenix at 12:20 p.m. Summer messages Lori that Adam and Zach are on the way from the Sky Harbor at 2:38 p.m. Chad calls Lori at 3:06 p.m. and they talk for 30 minutes. I'm so disgusted. This is the timeline. I'm going to put that in. Y'all bear with me. I don't understand why this is not keeping up. So she's like, you got lots to do. I wonder what they had to do. Wonder what their chores was. How did they know? How did they know? That old crazy Melanice. So let's see what Justin says. So Alex Cox brings a gun, a garbage bag of clothes to Lori's. That's all he needs to be part of the mission, says Kay. Lord have mercy. This is what Justin Lum says. Tracy says at 6 a.m. Chad and Lori were texting. Trey says until 7:30 Chad and Lori were texting. Yep, that's what Sis wrote. We're all kind of covering the same thing. THX. She's sitting in the courtroom and I'm copying tweets from other people in the courtroom. So sometimes they have almost the exact same thing. Yep. True. See what Nate says. Nate says on July 11th, Chad, Buddy texts Lori at 6:06 a.m. They text back and forth. Charles arrives at the house at 7:35. Adam warned Charles they're planning something. Last outgoing message from Charles was at 7:37 a.m. Poor little Charles. Poor Charles. Terrible. These people. Y'all. Y'all. Yeah, me too. Hottie's mind says, I have always wondered what Lori meant to Alex when she said, I need to come get the stuff from your house today. Yeah, I've always wondered that too. "47 minutes pass before 911 is called. Nate says an incoming message from Adam to Charles at 7:37 came in. It was not read until 12:13. Charles put JJ in his rental car. Lori takes Charles's phone and won't give it back. Alex shoots and kills Charles. Lori leaves with Charles' rental car with his phone and wallet. 17 seconds ago, Nate said Alex calls Lori at 7:52 a.m. Then he calls her again at 8:06 a.m. Alex calls 911 at 8:36 a.m. Police were advised that the shooting had just occurred. Police and fire were told CPR was given. Lori returns to the house at 8:48 a.m. Lori is interviewed by the Family Advocacy Center at 9:40 a.m. Hmm. Okay, let's see. Justin Lump says 47 minutes passed before Alex Cox calls 911. Kay says she also says 47 minutes to stage the scene. So that's what Justin said. Okay, so that's already read. Okay. Hmm. Okay, so 2 minutes. Okay, let's see what Nate says. They should be coming back pretty soon. Lori has Charles' phone the entire afternoon of the 11th. She calls Chad, takes photos of the phone. Lori calls the mortuary. None of Charles' family knows he's dead at this point. Lori and Alex return to the home at 3:11 when she gives the phone to the police. Good heavens, she had the phone all day. What is she whining now about? I want to know what's on that phone. Y'all I gotta check and make sure that we don't miss our stream. Okay, let's get it back over here. Look at this. No, they're still doing that. They're still doing that. Okay. Back over here. Trace says, oh, she said this is placed out so well. Now listening to Lori call the insurance. Okay. That's what Trace says, that she's having them call the. That's pretty good. Okay, Justin Lum, what say you? He didn't have anything real new to say. Nate. Trina talks about money being the motive. She plays Lori's call to the insurance company inquiring about the $1 million. She told Robin Scott that Charles had been accidentally shot. Okay. All right. Y'all. Trina says, you don't shoot someone twice in self-defense. See what Justin has to say. Trina Kay says the defendant is untruthful to various people. Well, do tell. The defendant, Lori Daybell, is untruthful. That's about as kindest way I ever put that. Natalie Huber says that's a true statement. It really is, isn't it? Okay, let's see what we got here. So, okay, let's see what Nate has to say. Okay, we already got that. Okay. Okay. Nate says even the smallest things this defendant exaggerates and minimizes and is untruthful. Trina Kay says Charles Vallow was not accidentally shot. her brother intentionally shot him. There was no accident when you shoot someone twice. That's pretty true. Go Trina. Go Trina. Go Trina. Oh my gosh. I can't believe it. Also, Trina displays the slide that says Lori's words show the motive of money. It's the text between Lori and Chad where they wonder if the life insurance was changed after he had 2 bullets in the chest. Woo, Nate. Trina is throwing down. I can't wait to hear it. I can't wait to hear it. Yes, we do get to see the closings, but it's a 30-minute delay just like the rest of it. So we should be pretty soon going back. Seeing what time it was when we did come back. Okay, 28 minutes ago, Nate said we're back in the courtroom, so that should be in about 2 minutes. We should get a stream, so we can be looking for it. Okay, Justin. Trina brings up visuals on a projector screen reading text between Lori and Chad after Lori Vallow Daybell learned she was not the life insurance beneficiary. It was probably Ned before we got rid of him, Trina reads. The Lori from Lori got rid of him. These are Justin's tweets. Okay. Then, okay, here we go. Justin Lump says, okay, now let's talk about Chad, the affair with Chad Daybell. She's putting it out there. Do you ever date a married man? Oh, Tracy said the jury's paying attention now, baby. I bet they're paying attention. Wow. Wow, wow, wow. This is a wow. What say you, Nate? Nate says Trina mentions the fake email account set up by pretending to be a woman named Karen Walker, asking Chad to come to Arizona to help Charles write a book. Charles found these emails and confronted Chad and Lori about the affair. Well, they were making up some shit. They were working overtime online in this bunch. And I do believe lying is probably against the Book of Mormon and the Bible. What is Tracy saying? Trace says they're talking about the 2 months that Lori disappeared while Charles took care of JJ. Bless his heart, bless his heart. It's gone. Okay, let's see what Nate says. Trace is ahead of him now because They're on to about Is it live now? Okay.
Go ahead and get the jury lined up, I guess. Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number, I believe, is 269.
That's what I understand, Your Honor.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations. All right, the jury is now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, he sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention, to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would,
He texted Adam and said, Al is here. Adam texted back, they are planning something. He knew. And 3 days later on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about
that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex, and they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming, and we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message. This one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad, 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. We saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. a loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? Gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car. And then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves. As Charles is laying, dying or dead on the floor, 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews, the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham. You see on her records that she again calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of flight reservations from Charles's phone. Not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant entirely handed over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages? Exhibit 230. It will be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, Not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad, the affair with Chad Daybell. We know that she knew him as far back as November of 2018 when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly Time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th, big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch and restaurants. This is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. So what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with, that she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs. And she said pretty much after that, the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him. Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say. Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
Okay. So it wasn't just you in a private conversation.
Correct.
She was open about it.
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words. From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that? What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself. Conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. Defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. It's where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day. And you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit it? Stop before I go into the intersection. You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles. Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he was saying this?
Yes, one of the times.
Okay. So he said it more than once?
Yes.
Can you describe for us part of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I probably was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, But Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th, again, we have Melanie who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is from Detective Duncan and from Adam that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that in fact, we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic sword wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back, before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. One, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30, pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around. He's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote. She is the one who on the 9th said, "We will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him." And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, She is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the night in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, because you don't have someone who says, I heard them say, we shall conspire. You can infer that from the conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclen, she was talking about how hot it was outside. JJ's out in the car. In the house with the kid? She's worried about her child out in the car? She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclin that Tylee comes out with this bat. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ? And so he put them in the car, in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for? You know, he's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother. And I was like, and so he was texting him on the phone when he first got to my house. And I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brother.
So when you listen to these persons, the interview of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened? How did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and... He comes back in, I wouldn't give him his phone. He was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there, and he was screaming at me. And I was kind of walking towards around the house with it, so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. Let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. Got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles, again, left-handed.
Field with your brother.
Yeah.
What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Left-handed? So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside, and what happened? Then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me to that and yelling at me to give him his phone still because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards. One arm.
Like he was swinging it backwards? He would have done
like he would have swung it backwards at me, not frontward.
Okay.
So Lori Vallow, detective, and planned that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, his arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Coombs told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun within Charles, 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it, someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who've come here and talked to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence, and you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So you know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have one kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son, Colby, isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We talked about a few things, but one of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. She's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. If this will play. When she was questioning Detective Enclam, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
Well, you know, now that you're not in Santan, this is your home.
Right,
Gotcha.
right.
Okay.
We just moved in.
Gotcha. How long have you guys lived here?
Okay.
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah. Okay.
That's why the neighbors don't know us.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You're told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believe that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles. They all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes.
All right, for the jury.
Wow, y'all. Y'all hear me? There's going to be a break, but they're going to come back. They're already back in, so I don't know how long. We surely won't have to wait a whole 30 minutes. Several jurors are not quite as attentive. Some of them heads are tilted like, really? Where are the kids? Yeah, that's going to be the big question. So let's see. They're still, they're still in the courtroom, so things are still going. And so looks like Lori is really arguing with them, and even though they're objecting, she just goes on talking. So okay, we'll share this tab instead. Nate says, Lori says she was shocked Charles changed the life insurance policy. She was not angry. Oh, please. She says Charles was providing for their family and she had no motive to change that. Lori brings up Nephi. This was the state's evidence to murder over self-defense, and it's utterly ridiculous. Lori says, in Mormon culture, Nephi signifies strong faith and courage. Trina objects as testifying. Judge sustains. Lori says, state is trying to retrofit a crime that doesn't exist. This event was not a crime, it was a tragedy. Don't let them turn my family tragedy into a crime. Pooh. Is what I got to say on that. So that's what Lori said. And let's see if Justin says, another objection by Trina as Lori brings up Nephi. Lori says the state trying to turn this story into an order to kill someone is absurd. Okay. Y'all let me, I gotta keep that, watching that. Justin, okay. So that's still the objection about Nephi. Let's see. Lori says the 2-minute period in their house changed their lives forever. Trina objects to testifying. Judge tells Lori not to testify about things not entered into evidence. How can you decide for another person if they feel threatened? Trina objects. Judge allows it. Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial I was praying for my husband even though we were having marital issues, praying for him to die. Oh my God. Oh my God, she's terrible. She is terrible, y'all. She is just terrible. I just can't even believe it. She's so terrible. Ah, but only you get to decide. The state put up witnesses that had zero knowledge of conspiracy. That's what she's saying now. Oh, Lord. Okay, 1 minute ago, she said only you get to decide. The state put up a witness that had zero knowledge of conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy. Then they showed you the sad effects of the family torn apart because of that tragedy. Lori finishes and walks away. Trina will now give a rebuttal. Oh my God. Well, that didn't take long, y'all. 38 seconds ago, the execution of Charles Vallow is not a family tragedy. There is nothing you can say to try to construe it in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. He was involved in it, but because he is a co-conspirator, we are not here to determine his guilty, albeit it is quite obvious. This must be Trina speaking. Okay. Okay, 23 seconds ago. Trina says, the defendant wants you to pretend when she's talking about Charles for months, agreeing to her brother killing him, having people tell her that's wrong, having people know that you're planning something, that those words don't mean exactly what they are. We got rid of him. What Trina says. She's still doing her rebuttal, y'all. I'm surprised that Lori didn't speak more, to be honest. Let's see. See what Trace is saying. Let's see what Trace is saying there.
Hey, Don.
Ooh, hey, come. How are you doing, honey? I know this is rough.
Oh, yeah. It's been a rough day. I was just wondering because people keep saying that it's on. So I was trying to
Oh,
get to you to tell you that it might be on, but I'm
well,
not sure. I didn't go look myself, is what I'm saying.
okay. Well, I'm
Uh,
going to look some more.
Okay. Hold on. I'm just trying to figure it out myself.
Well, it kind of is going to overlap. You know what I'm saying?
Mm,
Because they
I
only took a
know.
short break.
I hate it. I hate this delay stuff.
No, we don't want that.
Mm, thank you so much.
Well, you're very welcome. It's got to be the roughest day in the world, and she is such a brazen bitch.
Yeah, she
I'm
is.
so
She really is. The worst thing my uncle ever did was marry her. You know?
yeah. But she's kind of person that once you meet up with, she sucks you in.
Yeah, she does.
It's like a vacuum cleaner.
She is a vacuum cleaner. She abyssal.
I swear.
Anyway, one of them old antique ones. Anyways, I know that's so juvenile, but it's all I
Plus,
got.
plus Trina had a whole section on some stuff that we're gonna have to talk to her about, and
What'd she say? Which
well, that
part?
the part where she was having Adam, who probably don't go to the temple, and Serena Sharp, who don't know who Nephites are, to say that what Lori believed was not really mainstream LDS teachings.
Oh, Vic
Yeah.
says Hoover. Thank you. It's a Hoover. Yeah, not a
Uh,
Bissell. That's too
well,
good. Too good a brand.
well, Nate Eaton says Trina reminds the jury of Lori's religious beliefs, that she was exalted and didn't have to repent. And of course, she thought she was Nephi. Physical evidence on Charles and at the scene shows us he was executed. The state has met its burden because even if you somehow believe that Charles actually had that bat, it wasn't staged like the rest of the scene. The second shot is not justified for self defense. Arizona law does not allow you to execute a man on the ground. Thank you, Trina.
Wow. Yeah. I just, I mean, I think she did good. Y'all think she did good?
I
I just,
did.
I get a little lost in her sauce sometimes because it's like I don't know. I don't know if it's her voice. I mean, she's great. I totally changed my mind on Trina K. At first, I didn't even know who the attorney, who the prosecutor was. I never, not like Lindsay and Rob and Rachel, right? They kind of stood out. Uh, they spoke in public a lot, and then when we shifted to Arizona, it was like, wait, I don't even know who the prosecuting attorney is. Like, she didn't stand out, is what I'm saying.
Right, right.
And then learning about how, like, all the things that she wasn't going to be able to bring in and say, and then realizing throughout, during the trial, like, I realized all the things and how she was having to do the just all the
Right.
hurdles she was having to go around to appease the hooker, right? And so I'm like, how, I mean, hats off to her, straight up. I'm just like, I don't know how the hell she's doing this,
Right.
but so it's like, what?
And Lori is putting it in your face that they won't let Tylee speak. Like like she's saying to the jury, like, they won't let Tylee speak. Like
And
you
nobody's
bitch.
thinking that. I mean, you know what I'm saying? Well, I mean, we're thinking that, but they're not. They're not thinking that. They don't know about her and what happened to think about it. And that's
Well,
just
that
one of the
just
ways
makes them
she can brag.
that makes it even bigger. The fact that, oh, sorry, Brutus does not
He's like,
like something.
he's like, calm down, Mom. Thank you, KJ, by the way. I don't know if my thing you went through. Thank you so much. And Brutus, you better be good, boy.
I don't know what's up with him. Decided to lose his mind. I think that Caleb might have drove up out there, and I guarantee you, if anybody's in a quarter mile of the house, he
He's
don't
on it.
like it. He's like, they should not be here.
Yeah. I mean, I don't know. It just seems like it would have been a little more cut and dry, you know?
I think she went a little long. I saw people in the chat telling her to tie it up, to I think that it was the people in the audience in our chat felt like it was overkill. It was a really long closing, but I was reminded of things, and I think that they needed to be reminded too. So I know it was a little long, but she says the jury leaves. What's going on? What happened?
Oh, shit.
Trace, damn Trace, what happened? We missed it. We were not looking.
Vix Tech
Okay.
says Tylee is present. Yes, absolutely.
Okay,
Yeah.
the judge explains that 2 jurors will be picked as alternates. Jurors 14 and 5 will be alternates, both men, and they will be on standby in case another juror has the problem. The judge staff swore in to protect the jury, and they will now be walked out and begin to deliberate. That was it. Oh, okay.
When did Lori give her? Well, we're waiting on it. It wasn't long, I'm assuming.
Yeah, we're
You know,
waiting for them to come back
it's a
because
5-minute delay today?
no, it's a 30-minute delay
Oh,
still
30
today.
minutes still. Okay.
It's going to be
So
when we go to verdict. There'll be only a
I
5-minute
wonder
delay.
who said that, other people had it on. That's why I jumped on because I was like, oh crap, I know whenever you're on another page and you're reading from it, you can't see.
Well, too, it could be that they're seeing somebody reviewing part of it that we've
True.
already seen, and they think that
True.
it's up. And it could be that we're missing it too. So
Well, I know that's usually my case. So I just wanted to, I was like, okay, well, I don't know. So I just jumped in.
okay,
I
here, maybe.
text you too.
Oh shit, are we? Okay,
Oh,
so maybe we are about to come back.
oh, y'all just buckle up because from what I read from Trace and, in the courtroom, she's going to be a triggering hoe. So thank y'all for being here. Thank you again, KJ. Thank you, Donna. Thank you, mods.
Oh, you're welcome.
Thank y'all. Jason said, thank y'all.
Oh, by the way, I'm just remembering this from last night. Some of Paul's mods were in our chat last night.
Yeah, Miss Emily.
Yeah, and she said to send her regards.
Oh, she's a sweetheart. Hey, Natalie. Natalie says, "Hey, Crush, it's going down." I wish I
Yes.
was like excited. I'm just like, I don't know. It's like a train wreck, and I'm just shielding myself. Like I'm just like, oh, that's what it feels like. Not to mention, I had sciatic really bad last night, and oh my God, yeah. It was, very hurtful. I was in pain last night and then didn't feel good this morning. Didn't feel good today. Starting to kind of feel okay. It's just been a rough one.
So I wonder if either one of those. Here we go.
Let's get it on.
All right, please be seated. The jury is present.
Ding dong.
The defendant can proceed with her closing argument.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews.
Objection, Your Honor.
Or let you listen to the 911 call.
Right.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the three of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have an evidence, any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only three witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained, the jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was, self-defense, and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
Testifying at this point?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Right. Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
All right, the state does have the burden, so I have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we, because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with, as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
All right. Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers.
14.
Juror 14. Juror 5. I don't think you're 5. Well, maybe you are. Okay, so to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God?
Izzy, drop those off. Undrop those off.
All right, to the jury.
The jury is no longer present in the courtroom. I've passed out proposed aggravation phase jury instructions. In the event that there is a verdict of guilt, the state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long.
I could just stick on page 3. That's as a free.
Got it. All right, we'll be at recess until we hear from the jury.
All right.
There it is, folks. So tomorrow morning, they're coming to the courthouse that jurors are, and they're going to start deliberating. And when they come to a decision, they will announce it, and they'll give, I believe it's 30 minutes to get there. I'm not sure about that. I'm not going to be able to make it there. So it's not as important for me to know exactly how much time it takes as it is for the people who are there and want to be there for the verdict. So tomorrow, KJ says tomorrow. So tomorrow, yes, tomorrow they're gonna meet and they're gonna start their jury deliberation, and more than likely they will come to a decision by then. And we won't stay on too much longer. We've been on 6 hours, and Krisha will probably want to look over this and come back on at some point. And also, KJ is on tonight, so we'll want to go over to KJ's and see what she has to say. I believe hers is at 7 o'clock. I'm going to put a link in our chat for y'all to go and watch KJ later tonight. It's in 118 minutes from now, and I'm going to put that in the chat. And everybody, we will meet back. I'm not sure. Well, see, they're gone home for the weekend, so tomorrow they'll come back. Nothing can happen tonight, so it's gonna tomorrow they'll come back and they'll start doing deliberation, and then we're gonna get some kind of announcement that the verdict is in, and then we're gonna go live and cover it. And we hope that Trace and them make it there. I'm not sure how long it takes from Trace to get to her house to there, but I don't want anybody to get hurt doing it. So yes, last night's stream was really important for Cresha, as all of the streams are. But these are particularly difficult when they're talking about people you love and showing pictures of them, in the state that he was in. So what I'm going to say now is that we were here for justice for Charles Vallow. We're waiting on a verdict, and love always wins. That's what one of the things that Charles himself had put forth, and we want to make sure we say it. And so we're here for justice for Charles, Tylee, JJ, Tammy, and Joe Ryan, and any other people that this hussy has off that we may not even know about. So we'll be checking back in. I'm sure Cresha will have a live to go over this with you when she's had time to digest it and get it going through her brain. And so, as all of us have to think about this, so I'm going to go for now and remind y'all that we'll go over to KJ's later. And remember, love always wins. Well, there we go.